morning, everybody. Happy Tuesday. Episode number 202 of the Courtroom Files live, our last live show of the year. Let's get it started with Judge Simpson.
Morning in progress. I don't want to interrupt you.
So, did we catch any of that?
It was all in on a recording. Yeah, you're good. Don't worry. You are.
So you stopped me for what reason?
I should have just pushed a button.
And not told me?
Yeah.
Okay. Glad we're getting along. I'm also glad 2025 is ending. Court does call the case of the people of the state of Michigan versus Derek Smith.
Ashley Feltus for the people.
Good morning, Anna. I was appearing on behalf of Derek Smith, who is joining us via Zoom. Derek, would you unmute and state your name for the court, please?
You got him?
Yeah.
Okay.
It's probably your second.
Hi, my name is Derek.
All right, got him. All right, what are we doing?
There's a PCC adjournment sheet in the file. I'm looking to adjourn the PCC once more for discovery and investigation due to our recent action.
Probable cause conference without objection will be adjourned to January 15th. 2026, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you.
Thank you, sir. Court does call the cases of the people versus Wesley Brand.
Alan, is that on behalf of the people?
You have to push it. Hey, I don't have that key.
And Alex Warren Green on behalf of Mr. Brand. Mr. Brand, could you please state your name?
Wesley Brand.
State your name again, please, sir.
Wesley Brand.
Okay, thank you. All right, what are we doing?
Your Honor, I'm asking to adjourn both of these matters so that we can complete discovery in each case.
So, the discovery issue.
Your Honor, in the 1713, there is outstanding media discovery. I spoke with the people. I believe they received it and are sending that over if they haven't already. In the 2209 case, we need paper and media discovery, but I did speak with the people on both fronts.
And Your Honor, both of those should be coming over to defense, and there is one video that I requested that wasn't media discovery that I'm waiting on as well from YPD.
All right.
And I don't believe their records office will be out until next week.
You can just stop there. Are these the only cases holding him? Do you know?
He also has another case out of 1481 for assault on a corrections.
That's correct, Your Honor, and nothing out of county.
Probable cause conference, January 8th, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you.
Thank you. Court does call the case of the people versus Stephen Black.
And is that on behalf of the people, Your Honor?
Your Honor, Joe Simon on behalf of Mr. Black. And Mr. Black, state your name when you get here.
Stephen Black.
Take your hands out of your pockets.
And Your Honor, I hope the court has signed my substitution of counsel.
Nope.
I asked the court.
Yes, I did.
And accordingly, requesting to adjourn the PCC as I've just entered the matter. I know the court loves when I request dates, but the date of the 15th would work well if that's possible.
Why did he do that?
Because I know you love.
No, why did you do that?
I know you love.
I'm 3 cases in. January 15th, 2026, 9 a.m. Bond continue.
Your Honor, regarding bond, well, I'm sorry, you talked to, I couldn't get it in. What should be relatively easy? the current exclusion zone of the tether includes my office. And so if the court will amend that to allow my office to be permitted, I'll have my client report to community corrections and they'll figure out it's literally on the border of the exclusion zone.
Your office is.
Yeah.
Any objection from the people?
And the other one, I already told.
Another?
Yep, but I know what the court's going to say, but anyway, there are two family court orders regarding contact with my client's minor children and his spouse. One is a PPO order and one is a family law order, both before Judge Slay, and they are actually in conflict with one another. So
Judge Slay's orders?
the people with the one was entered ex parte. They're just minorly.
Judge Slay entered orders that are in conflict.
She's not. She's.
Let me call her.
They're great.
You said that.
She's not aware of this, but I'm sure. What I'm asking if the court would permit contact as Judge Slay orders with the minor children and my client's estranged spouse for child visitation purposes only.
Is there a response from the people?
I think once we review the order, we can submit a step report after we have everything kind of all.
Right, and typically, unless the people perceive some other danger that the family court may not be aware of, I will follow the family court's order. But if the people do object, then I would certainly make a more restrictive order. Okay, so I will allow the zone to be amended so that your office is outside of it, or they can keep the zone, but a violation would not occur if he's at
Either
your
way.
office. And then you guys can get to me the order. Council approach briefly, just.
All right, good morning once again, everybody. Welcome to the Courtroom Files Live. Apologies for a moment or two of silence there. I had to step out of the studio because we had cats acting like fools, so that had to be dealt with. Barbara, thank you for gifting me a membership to my own channel. Very much appreciate it. Yes, that is the third time by my count I have been gifted a membership to my own channel, so appreciate that. Looks like Judge is back, so let's continue with him.
You think that needs a new order?
Probably his zone. Mr. Simon's getting been just on the outside of the zone.
I think I can just put like no violation to address, and that's good.
I think you can do it that way, but the other thing is, I'm not sure where the prohibited premises is vis-a-vis that zone.
It's on Cook Street, KOCH, which is a couple of blocks from my office.
That's the excluded area.
Yes.
Oh,
So the perimeter literally touches my.
got it.
Yeah.
Got it. So, okay, they'll have to figure something out. They know where their prohibited zone is. We'll work.
All right. Thank you.
Thank you. Court calls the case, People versus Stephanie Cruz Mena.
Good morning, Your Honor. Jeremy Blake appearing on behalf of Stephanie Cruz Mena via Zoom. And Stephanie, when you reach the podium, could you please state your name?
Oh, there's Mr. Hunt. Okay.
Oh, Stephanie Cruz.
All right. She stated it. Go ahead, counsel.
Thank you, Your Honor. We have received the discovery Friday from the people. There's quite a bit to review as well as some investigation on our end. We would ask for a short adjournment and to address bond.
All right. Without objection, probable cause January 8th, 2026, 9 a.m.
Thank you, Your Honor.
Bond will continue. Thank you, Mr. Clark. Court calls the case of the people versus Edward Dagnes.
Comes over what the prosecuting attorney for the people.
And Your Honor, Joe Simon on behalf of Mr. Dagnes. Ed, state your name, please.
Edward Dagnes. Thank you.
All right, we are trying to work out a plea agreement in this matter. The issue is determining what the restitution number is going to be. My victim advocate has been in contact with the victim in this case. There's been issues around getting cost of potential medical bills and insurance repayments. So if we could get an adjournment on this matter, Your Honor, I will follow up immediately, try and get this to Mr. To get it to counsel as soon as possible.
And Your Honor, I'll just add one more thing. There's also a piece of discovery that I want to keep on the radar that we need to.
And I have reached out to the DEC about that. Your Honor. If we can get it, we will have.
All right. January 15th, 2026, 9 a.m. Bond continued. I don't have a green.
Thank you, Your Honor. Ed, if you can get one.
I don't have a green sheet. For Mr. Simon.
Oh, you don't.
I don't have a green sheet. Apparently,
No.
he thinks he doesn't have to.
No.
That's.
No.
You'll address that.
Mr. Overwater was going to totally eat that bullet, Your Honor, but because that wasn't on me.
That is true.
I don't believe either one of you.
Happy New Year.
I don't believe either one of you. You're just covering. Court calls case of people versus Amari Harris.
Kenneth Overwater, Assistant Prosecuting Attorney for the people.
Is that it for you, Mr. Simon?
Happy New Year, Your Honor.
And to you. I did not want to give you holiday greetings like the last time.
Thank you. A little hurtful.
Yes.
Good morning, Your Honor. Wendy Barnwell, P42505, on behalf of Mr. Amari Harris.
Your name, sir? Amari Harris. Thank you. All right, what are we doing?
Your Honor, we're requesting an exam. I know the last time we were in court, there were another lawyer had showed up, but we're asking for an exam.
All right.
And a
Does he have a
co-defendant.
co-defendant? Does he have a co-defendant?
He does, Ms. Cruz Mania, that was just adjourned to January 8th.
Okay. But he's requesting an exam.
Your Honor, Jeremy Glick on behalf of Ms. Cruz Mena, I'm still in the courtroom. If it's relevant to the court, we'd be fine as well doing an exam if we could push that until the 15th to give us 2 weeks for some additional discovery and investigation.
So, well, the exam would be sometime that week. I don't know. I would normally be setting this for what, the 6th?
Yes.
But the 13th. So I can set exams in both of those matters for the 13th, if that will work with counsel.
That would work for us, Your Honor.
Yes,
It
yes,
would?
Judge, that would work. I'm already in court in an exam that day in front of you.
Okay, so let me take care of this one, and if you can hang on a second, Mr. Glick, and the discovery at least is complete, relatively speaking, to proceed to an exam. Would the people have their witnesses available the 13th?
I'm sorry, Your Honor, I apologize.
Would the people have their witnesses available January 13th?
I don't see any reason why we would not.
All right. Is it mine? Huh? Oh, we don't have a.
Correct, yeah.
Just because it's a capital. Can we try to find out what they're doing? Because I don't. Maybe we'll know by Monday, but maybe, who knows? All right. So I'll set preliminary examination on both of these cases for January 13th, 2026, 9 a.m. That's before me. That's in person, but we'll continue. And Mr. Glick, on your case, Would you like your client brought out if I was setting that date or?
No, Your Honor, I can connect with her in the jail and let her know.
All right, so waiving the appearance, I will also set preliminary examination in that matter for that same date.
Thank you very
All
much.
right, thank you, folks.
Thank you.
Thank you, Judge.
Michael, thank you for gifting a membership. Very much appreciate that. Let's change it up. Let's go to Florida for first appearances, but Anna Garcia is handling them this morning, so a little different.
Excellent. Now, I see that there is already a dispo set. So is this an initial first appearance or are we bringing him back up? Counsels?
Jake has to bring him up. Jake, I guess.
Mr. Mitchell, you may proceed. What is the purpose of bringing Mr. Leonard back up?
Yes, Your Honor. I contacted Miss Amanda Seal, who is the alleged victim in this case,
Yes.
regarding, she contacted our office originally, want to discuss potentially modifying the terms and conditions of the bond that was set by Judge Roberts over the holiday weekend.
Okay.
She was requesting nonviolent or peaceful contact with Mr. Leonard. She has expressed to me that she's interested in, dropping charges in this case. I said, we'll deal with that down the road. But for right now, we can bring him back up, modify the no contact provision for purposes of her contacting him and paying the bond to get him out of jail.
Okay. And Miss Seal is present in the courtroom?
Yes, Your Honor.
Miss Seal, will you please come on up? Miss Seal, come on up. I want you to stand in front of one of the microphones. Miss Seal, good morning.
Good morning.
If you will, please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, Miss Seal, you can put your hand down. Miss Seal, tell me your full name for the record.
Amanda Ashley Seal.
And how do you know Jason Leonard?
He's my boyfriend.
Okay. Miss Seal, there was allegations that on December 23rd, there was an altercation between the two of you. Are you aware of those allegations?
I have not been over the report, but yes, I'm aware.
And the judge that first appeared, Mr. Leonard, indicated that you were to have no contact with each other. The state is indicating to me that you may wish to have no violent contact with Mr. Leonard. Is that right?
Yes, ma'am.
Do you intend to live in the same home?
We have no family out here or any friends. We just moved out in July.
Okay.
We live
From where?
From West Palm Beach.
Okay. Who is with you today?
This is my very good friend, Donald Pagano.
Okay. And is he related to Mr. Leonard in any way?
No, ma'am.
Okay.
Just
All right.
a support system.
Okay, fair enough. I was just curious who is here. So you guys moved here from West Palm. You guys live in the same home,
Yes.
correct? Okay. And so tell me, do you want to continue to live in the same home?
At this time, we do.
Okay. And you want to be able to post the bond?
I do.
Is there any place where he could stay that is other than your home? And I'm happy, Mr. McDaniel, to consider this from your side and also from Ms. Seal, if you know, even for a short period of time.
I can find a friend or my mother or somebody and go and stay with them for a little bit and he
All
can
right.
stay at the house.
Mr. McDaniel?
Your Honor, I think she also maybe, because she's going to be paying the bond, or is requesting maybe some kind of bond reduction if the court feels inclined to. Just to let the court know now, this is I don't recall, I'm trying to remember what the complaint was, but I don't recall it being a major battery, if I can put it that way. And both parties were arrested, and the officer said he could not determine who the aggressor was. And both parties got, just to make sure you're aware of that both parties were arrested. He couldn't determine who the
Okay, I
aggressor
had not read to the bottom end, but I did see that they're displayed consistent physical altercations, redness and scratch marks on the chest. Yes, so there would, okay. Let me ask this. What kind of history did they have, Jake?
Let me double check. I looked at it yesterday, but I can't remember it off the top.
Okay, just take your time and let me know what kind of history they had. John, what normally happens? Is it anger management or BIP? If there's history, probably BIP. If no history, anger management, right?
Yes.
We only do
Stacy probably a better.
we
better,
do
uh,
have
line.
embracing change, FYI. We do have that ability, guys.
My
Yeah,
recollection of the
Embracing
history
Change
was.
is with CARE. It's a 20-something week program, and Embracing Change is very actively, or CARE is very actively in the process and on the last stages of getting certified for BIP. Yeah, so FYI.
Judge, my recollection of the criminal history is off my recollection. Jake's probably gonna remember more. He's looking at it. Was some drug charges all from West Palm Beach, over.
Any violent history?
Mr. Leonard has,
Okay.
Mr. Leonard has a few former batteries, but they were,
How long ago?
it looks like 2015, but they were all dropped or abandoned.
Okay. What about Miss Seal? Have you ever been, I don't want you to tell me details or anything, but just have you ever been charged with any crimes of violence, including battery, aggravated battery, or otherwise?
I actually don't know how to honestly answer that. When I was 18, I was arrested for domestic violence, but I think it was dropped.
Who was the
for-
victim? Do you remember?
Honestly,
Okay.
I don't.
Let me ask you this. How long have you and Mr. Leonard been together?
A little over 8.
Okay. You were not the victim in the 2015 batteries. You did not know him in 2015? All right. So, Jake, John, help me with anger management. How soon could they start classes? I'd like them. What is it? So what is it, like a 4-hour? What is it?
I think it's a 4-hour course, Tim.
If,
Oh, I should have asked you, Tim.
no, ma'am, Dr. Spires' office offers anger management. It's I think it's 12 weeks. They'll go one time per week. CARE has it, but CARE, if they have.
It's a lot
class
longer.
that's already started, they have to wait.
I didn't realize that it's a 12-week course with Spires. Okay. All right. So here's what I'm going to do. Okay. I am certainly going to consider the request for a reduction of bond, but I will allow non-violent contact between the two of you. Right now, you may immediately have contact for the purpose of posting the bond, and that would be through a telephone or text. You may then have in-person nonviolent contact. Mr. Leonard, do you want that? John, I didn't ask him. He's the victim of the other. Does he want it?
He does.
Okay. I will allow you to have nonviolent contact with each other in person after you have both completed 3 anger management classes. So if it's a weekly class, after 3 weeks, you may have no nonviolent contact with each other in person. You may have nonviolent contact with each other telephonically, but I need to make sure that that this doesn't happen again.
I understand
Yes,
that.
ma'am.
My question about that though is if I'm going to be leaving to go to like my mother's or a friend's, that's nowhere close.
Do you work outside of town?
I am trying to start a business actually from my home.
Okay. You can do an anger management anywhere.
Okay.
Okay, so you just have to, or what
And this
type
is
of
once a
release
week?
is she
How many
on?
times?
3 times. I want you guys to go to the first 3 classes, or Tim, tell me, is she on a conditional release? What kind of release are you on? Are you out on bond or?
Yes, ma'am.
Bond? I mean, we can give you information of where you can find anger management, but the ones that we normally do here is the 12-week, right? Now, if you complete, because you're not local, the 4-hour anger management, then that's sufficient for me for the nonviolent
Are these able to be
contact.
done from home remotely? Because Jason has no license.
Yes.
Okay.
Well, not Spires, but the other. How does the state and the defense feel? And Tim, how do you feel about doing the regular anger management that, what we traditionally?
Right. I have no problem with it. I mean, it's not an issue with me. I know there are some online anger management classes that Judge Murphy doesn't typically.
I don't love those, but are there any other?
The only
In person?
classes I know is Dr. Spires and CARE.
CARE does like a 4-hour one, right?
I think theirs is like a 8 or 12 week course.
Embracing Change is a 20-something week course, but they don't have the short anger management course either. I'll let you guys, so you guys figure out how this whole, the case is going to be resolved. But if you guys do the 4-hour online anger management, you may have nonviolent contact, but that is only a condition of the release. It may be that once your cases are resolved, that the state and the defense and the court, the judge sitting here, is going to want a stronger anger management course. So I tell you that to say that you may want to go ahead and get started with the more intense anger management course that's in person. But if you choose not to, in order to have nonviolent contact, you must complete the online anger management course. But that may not. And let me be very clear, and this is being recorded and Judge Mercer can listen to this, that may not satisfy an anger management requirement in the future should anger management be required as a term of a resolution in this case. Okay?
Yes, ma'am.
All right. Do you understand that, Mr. Leonard? And will you explain that to him, John?
I will, Your Honor, and,
That we use for the, he doesn't do online retail theft, but I can give them the same website. They have an anger management on
Perfect.
there.
Perfect. There's a website that has anger management options.
we'd ask the
But
court maybe to-
before
I know
then, you may
she's paying-
talk on the phone or text message for the purposes of the bond. Okay? And now, John,
since
you
she's-
were,
Since she's gonna be paying the bond, I was thinking maybe the court would entertain maybe a $300 cash bond that she could pay at the jail to get him released. Is that,
Is
if she could pay that?
is your client in agreement to a cash bond with no other component? Meaning, like, not give him a surety bond option. I think it's
Just not a
I don't
surety
think,
bond.
do what?
Yeah, just a cash bond instead of a surety bond, just.
Yeah, I'm just asking because I think technically I have to give him the option of a surety bond unless you tell me he has no objection to a cash.
We have no objection to a cash bond.
What says the state?
State has no objection to a cash bond either.
All right, so the bond is currently set at 3,000. I am happy to set it at a $300 cash bond to be paid into the registry of the court. And ma'am, what you can do is you can pay that in cash at the Jackson County Jail. Okay, all right, but you guys have to finish, you can't take him home. You got to have a friend, somebody else. You guys have to finish that class before you can have nonviolent contact in person. Both of you have to finish it.
So when I go to do that, I can drop off like clothes for him to be released in his phone?
Sure.
Okay.
You can. What else? What other questions do you have?
So
I
just.
think that's it at the
have them, I guess,
moment.
Your Honor, when they
Go
complete
ahead,
the
John.
online class, print off that certificate and bring it to probation so they can file it when the court files so they can show.
Not probation. I would say bring it to the clerk of the court so they can file it in the court file. So each of you will have to come to the Jackson County Clerk of Court's office. It's more than likely going to be Miss Williams right here that is in front of you. She will take the copy of the certificate. She will input it into your court file, and that will be proof that you guys have completed it. And then at that point, nonviolent contact will not violate the terms of your bond. If there is violent contact with each other, I will make sure you get taken back into custody and you will be held without bond until the resolution of this case. So this is only nonviolent contact that will be allowed, okay?
Okay, so at this time, I'm able to go to the jail, bond him out with cash. Someone
Bring
else
stuff
has
to
to
him.
come and pick him up. And are we able to be in the same house while I gather my things or?
No, I'd rather you not be
Okay.
in the same house. Now, realistically, this class is relatively short. You could have probably get it done within the next 24 hours.
Okay. Well, thank you very much. I appreciate your time.
Yes, ma'am.
Your Honor, I
Yes.
don't know if they were given notices for the next court date, but their next arraignment date for the both of them is February 2nd, 2026.
Okay, and ma'am, we're gonna have you sign a document.
Assuming Mr. Leonard gets out of jail today, of course.
Plan. Thank you very
Okay,
much.
oh yeah.
And guys, what Tim is telling me is that there may be different, Mr. Leonard, sit tight for 1 sec. There may be different a number of hours that are required on the online. I am okay if you complete a 4-hour class. There may be an 8-hour, you don't have to do the 8. There may be a 2-hour, you can't do the 2. It's got to be the 4-hour online anger management class, okay? Mr. Leonard, the prosecutor would also like to let you know that your next court date, because it appears as though you are going to be leaving custody, I'm also going to ask the jail to please give you a notice to appear before you leave. So if you guys could please do that. Jake, what is his next arraignment date?
February 2nd, 2026. Is that right, Dawn?
And that's going to be at the Jackson County Courthouse, second floor. Donna, did we get that right? February at 9 a.m. February the 2nd, 9 a.m., Jackson County Courthouse, second floor.
Amanda Seal.
SEAL.
Yes, ma'am. Yes.
Battery, yeah. Any other thoughts?
Next case, Your Honor, is Michaela Scott.
All right, thank you. Ms. Scott, your family members are here on your behalf. Ladies, who do you wish for me to tell that's here on her behalf? I'm sorry? Her aunt? And who else? Miss Virginia Tranquil is here, and your aunt is here also on your behalf. What is your first name?
Barbara.
Barbara. I'm sorry, I couldn't hear you. And your aunt Barbara Michaela is here on your behalf, okay?
Yes, ma'am.
All right. Ms. Scott, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
All right. Ms. Scott, you are currently being held for allegedly violating the terms of your county probation. That is a hold without bond because the allegations are that you committed a new law offense while you were out on county probation. Please listen carefully to your attorney, and then I'm going to ask you some questions. Mr. McDaniel?
Thank you, Your Honor. Your Honor, I've spoken to Ms. Scott in case number 25587 CT. She's going to admit that she violated her probation. Understanding that she's going to be sentenced to 60 days in the county jail. She'll have 3 days jail credit. And also in discussions with the state, we're going to continue to withhold adjudication on her. And any remaining fines be part of the order, and she'll work those off while she's here in the trustee bay working.
All right. And there is no objection to a recommendation of trustee?
I have no objection.
The remaining fine balance is $473.
The remaining fine balance is $473. If she wishes to work those off while she is at the jail, she can't get trustee time and work those off while she is at the jail, but she can work them off at the jail if she wishes. Ladies, do you have any questions? Yes, ma'am. So here's what's going to happen. It's 60 days jail sentence is what would normally be the sentence for something like this. She has credit for 3. If while she's in custody, she has good behavior, she would be entitled to 5 days off each month. So take 10 off that. Also, if she works as a trustee, for example, they need help in the kitchen cooking, or they need help doing things that you wouldn't normally have to do, right? Then you can get an extra 10 days off of that 60-day sentence. It's 5 days each month. So arguably, best case scenario, she could get 23 days off of that 60 days. Do you have any other questions? Yes, ma'am. Her LPN license?
No.
Her attorney has been able to negotiate that it'd be a withhold of adjudication of guilt. The state attorney's office has not objected to that. So what that would mean is that she's not adjudicated guilty of the underlying offense of reckless driving. So John, does that mean she keeps her license?
Well, she's not going to get her license suspended because of this case or any points that would suspend her license also. Now, I'm pretty confident she's going to have her license suspended because of DUI. That's the whole nother issue, and she'll have to go through the DUI school and everything associated with that to get her license back. She'll just have to deal with Florida Department of Motor Vehicle. It may take a little bit of time for them to to send everything to Florida, since I know it happened in Georgia, but her license, if not suspended already, they will be suspended.
Does that answer your questions? Okay, but it's more because of the Georgia. That's a good point. It's not so much because of the reckless here. Okay.
And Your
All
Honor, if I
right,
can let the
Ms.
family know also, just let them know that, I know she has a court date in Holmes County in a couple of weeks. She needs to they need to try to, if they can, let Holmes County know that she's in jail here. Also, she has a court date coming up for DUI in Georgia, so they need to try to let the officials in Georgia know that she's in jail here. So maybe they won't put a warrant for her for not appearing.
Jake, will you please reach out to the prosecutor in Holmes County and make sure that they know that she's going to be serving a 60-day sentence? But family, more important, here, we can pretty much kind of let people know here and they'll know because they have access to our systems. But Decatur County is different. And so if you guys can please call up to the clerk's office, let them know she's in jail here in Florida on a violation of county probation, that would be helpful to her so that they don't think she's just not appearing in court. Okay. All right. And Jake, you'll let Holmes County know?
I'm letting ASA Cook know right now.
Perfect. Thank you. And you might want to copy whoever is it a misdemeanor in Holmes?
Yes.
The misdemeanor secretary, because Jake may or may not, who is it, John?
Misdemeanor. Okay, never
Yes,
mind.
both of them.
This is a misdemeanor. I was thinking it was a felony, but it was a misdemeanor.
Yeah, okay. So that's kind of where we are. Ms. Scott, did you hear, or if you will, please raise your right hand, ma'am. Ma'am, do you solemnly swear or affirm that the testimony that you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you, Ms. Scott. You may put your hand down. Tell me your full name for the record.
I got you.
Tell me your full name for the record.
Oh, Michaela Mariella Scott.
Ms. Scott, did you hear what Mr. McDaniel said about resolving your alleged violation of county probation?
Yes, ma'am.
Is this how you choose to resolve your case?
Yes, ma'am.
Has anyone promised you anything other than what Mr. McDaniel just said to get you to enter into this admission of violation of probation?
No, ma'am.
Is anyone threatening you?
No, ma'am.
Ms. Scott, do you understand that by admitting that you violated the terms of your supervision, you are giving up a right to go to a VOP evidentiary hearing where the state would have to prove that you did what they say you did?
Yes, ma'am.
Do you also understand you are giving up your right to present any defenses that you may have?
Yes, ma'am.
And do you understand that you are giving up your right to appeal anything except an illegal sentence?
Yes, ma'am.
Are you doing this of your own free will?
Yes, ma'am.
All right. Ms. Scott and Mr. McDaniel, do you stipulate to a factual basis for purposes of the admission?
Yes, Your Honor.
All right. Then, Ms. Scott, I find that your admission is knowingly and voluntarily entered into after the advice of counsel and that there is a stipulated factual basis for purposes of said admission. I will now proceed to sentencing unless I hear otherwise from either the state or the defense. Ms. Scott, in Jackson County case number 25 CT 587, I accept your admission to the violation of supervision. I am going to revoke the terms of your supervision, sentence you to serve 60 days in the Jackson County Jail with credit for 3 days you've already served towards that sentence. I will also allow you to be considered for the trustee program should you qualify. I order that all of your unpaid monetary obligations should be reduced to a civil judgment unless or I guess, how do we say it, Don? Do we reduce them to a civil judgment? However, you may work those fines off in jail at the specified rate. Is that what I should say? Okay. So any questions about that? Your fines and court costs of $473 are reduced to a civil judgment, but if you choose to work those off in jail, then you may do so, and you may come out with zero. Ms. Scott, I'm sure your attorney would recommend that you try to work those off in jail because those could affect your license down the road if you're not making payments on that fine, okay?
Yes, ma'am.
I am required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. The court will continue the withhold of adjudication of guilt. Anything further from the state?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
All right. Ms. Scott, questions for me?
No, ma'am.
Family, any further questions? Thank you for being here on her behalf. All right, Ms. Scott, I wish you well. Mr. McDaniel, I'm happy for you to call the cases as you wish.
Thank you. Sean Blevins.
It's a DOC release, prison release. Mr. Blevins, good morning.
Good morning. How are you doing, Ms. Garcia?
I'm well, thank you, Mr. Blevins. Mr. Blevins, did you understand and hear the rights that were explained to you on the first appearance video?
Yes, ma'am.
All right, Mr. Blevins, you are currently in custody for allegedly violating the terms of your release from the State Department of Corrections. Most importantly, the alleged contact that you had with someone under the age of 18. Mr. Blevins, I am going to hold you without bond to see what DOC is going to do as far as that release, which means you can't be released from custody pending that resolution. Do you have any questions for me?
Yes, ma'am.
Yes, sir.
So this ain't got nothing to do with like the U or the regular state or anything?
No, sir. Unfortunately, this is just a Department of Corrections issue because it's my understanding that you were in prison and you got released on some sort of supervised release, right? So
Yes,
that
ma'am.
it's not the state attorney's office in the 14th Circuit or this court because you're not on probation for us.
Yes, ma'am. Do you know how long it might typically take for them to come see me?
2 weeks, sir.
2 weeks?
Yeah.
Is that what you said, John?
Yes, Your Honor, about 2 weeks.
Okay, 2 weeks. Okay, yep, about that time.
Right.
John's the one, John and everyone who's here normally is who knows that more than me because I don't deal with this as often.
Yes, ma'am.
But with that being
Okay.
said, they can open up to March. I mean, they normally see it within 2 weeks. It could be longer, but they don't.
Is March his EOS date?
Yeah, that March is his EOS date. And they don't have to have a reason. They normally do come within about 2 weeks.
But they normally do come. All right. All right. So that's what we got, Mr. Blevins.
Yes, ma'am. Thank you.
Good luck to you, sir.
Jan Caps.
Ms. Capps, good morning.
Go ahead.
Good morning.
If you need a second, Mr. McDaniel, you may talk to her and then just let me know when you're ready.
Thank you. We're ready to go.
All right. Ms. Capps, tell me your full name for the record, please.
Jan Renee Capps.
Ms. Capps, did you understand the video or the rights that were explained to you on the first appearance video?
Yes, ma'am.
Ms. Capps, you have been charged with one count of driving while license suspended or revoked. Ms. Capps, this could be a second-degree misdemeanor punishable by up to 60 days in jail or as high as a third-degree felony punishable by up to 5 years in prison. Ms. Capps, I do see numerous prior DWLSRs on your record, and so I think this might be as high as a third-degree felony. Ms. Capps, I've reviewed the probable cause narrative. I do find that there is sufficient probable cause for that charge. Ms. Capps, are you on probation anywhere at this time?
No, ma'am.
Ms.
I
Capps,
haven't
do you
been
have
in any
any
trouble in 5 years.
Sure. Ms. Capps, do you have any pending criminal charges? I know that you just said you haven't been in trouble in 5 years. I just need to know
No,
the
ma'am.
answer to that question. All right,
No,
give me
ma'am.
1 sec.
And Your Honor,
Yes, sir.
I did just want to state, me and Mr. McDaniel were in discussions about a potential plea offer
What you
this
got?
morning.
Tell me what you got.
My initial offer was going to be the first degree misdemeanor level of DWLSR, but
Okay.
I did not have a chance to look at her history. And based on what you're telling me right now,
So
this
here's
could-
what I got. I have in 21, I have a DWLSR. What was going to be your offer?
it was going to be 1 year probation, but if
Oh, yeah.
if
Okay.
it's potentially could be felony, I might need time to review this before I can go forward with any offer. So I think for purposes
I don't
today, it may
think
be
it's-
best just
John,
I don't
what you
think
know?
it's a good fit. Because I didn't see, the one in 21 got dismissed, and she had some others, they probably prior. Georgia's are not going to count against her because if they were, I'm just guessing maybe Georgia, Alabama, because those don't require knowledge, so those are not even going to be enhanceable. I didn't see anything in Florida. Now, I don't see Georgia or any other state.
Here's what I got, John. I've got dropped abandoned in 21, and I think it's the same. Dawn, you don't pull driving histories anymore?
I just wasn't aware that I needed to.
Oh, it's okay. I just didn't know if you had it, is why I'm asking.
I can get it really quick.
How quick?
We're gonna come back to her. and
Yeah,
get
let's
driving.
pass her. Why don't we pass her? Because that might be beneficial to her. And then Dawn can get it.
Yeah.
All right. Who you want to call
So,
next?
Cleveland Dixon, case number 25609 MM Cleveland.
Fair enough. Mr. Dixon, good morning.
How you doing, man?
I'm all right. Thank you, sir. Mr. Dixon, tell me your full name for the record.
Cleveland Dixon.
Mr. Dixon, did you understand the rights that were explained to you on the first appearance video?
Yes, ma'am.
Excellent. Mr. Dixon, you have been charged with one count of trespassing. It is a first-degree misdemeanor, punishable by up to a year in jail and/or $1,000 fine. I have reviewed the probable cause narrative, and I do find that there is sufficient probable cause for that charge. State, defense, how do you wish to proceed?
I believe
Yeah, we
Mr.
have-
McDaniel may have something. Yes.
We have a resolution to the case, Your Honor.
All right.
Your Honor, Mr. Dixon, I spoke with him about this. He's going to plead no contest to the charges listed. He'll be sentenced to 9 months in the county jail. He'll have 7 days jail credit. There'll be a $370 fine. This will run concurrent with any other sentences he may have. And he also be adjudicated guilty of this crime.
Is this the agreement with the state?
It is, Your Honor.
Does the defense stipulate to a factual basis for purposes of the plea?
Yes, Your Honor.
All right, Mr. Dixon, please raise your right hand. Sir, do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. Mr. Dixon, you can put your hand down. Mr. Dixon, did you hear what Mr. McDaniel announced about resolving your case?
Yes, ma'am.
Is this how you choose to proceed?
Yes, ma'am.
Has anyone promised you anything other than what he said to get you to do this?
No, ma'am.
Is anyone threatening you?
No, ma'am.
Mr. Dixon, do you understand that by entering into a plea today, you are giving up your right to go to a trial where the state has to prove that you did what they say you did?
Yes, ma'am.
Do you understand you're giving up the right to present any defenses you may have to the alleged conduct?
Yes, ma'am.
And do you understand that you are giving up your right to appeal anything except an illegal sentence by this court?
Yes, ma'am.
Are you doing this of your own free will?
Yes, ma'am.
All right, Mr. Dixon, I find that your plea is knowingly and voluntarily entered into after the advice of counsel and that there is a stipulated factual basis for purposes of the plea. I will now proceed to sentencing unless I hear otherwise from either the state or from the defense. Mr. Dixon, in this case, I accept your plea of no contest to one first-degree misdemeanor count of trespass. I adjudicate you to be guilty of the underlying offense, and I sentence you to serve 9 months in the Jackson County Jail with credit for 7 days that you have already served towards that sentence. This sentence shall be served concurrent with any other sentences that you may currently be serving. I order you to pay court costs, fines, and fees in the amount of $370. Those will be reduced to a civil judgment, but Mr. Dixon, much like you heard me tell Ms. Scott, if you wish to work off those fines, and I recommend that you do, you may do so while you are in the jail. If you don't work them off, then those will be just a civil judgment against you. Mr. Dixon, is there any objection to being considered for trustee status?
No objection.
Mr. Dixon, if you are eligible, you may also serve as a trustee. That is a program you must qualify for. And if there's a place for you where you can do additional work, then that may get you a little bit more gain time on your sentence. Mr. Dixon, do you have any questions for me about the sentence that I have just imposed?
No, ma'am.
And no? Okay. Anything further from the state or the defense?
No, Your Honor.
No, Your Honor.
Did I already tell him his appeal rights? Mr.
did not.
Dixon, I'm required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. Mr. Dixon, I wish you well, okay?
Yes, ma'am.
All right, thank you.
I think this is Lewis Phillips.
Lewis Phillips.
Good
Case number
morning, Mr.
25.
Phillips.
Good morning, Judge.
Mr. Phillips, tell me your full name for the record.
Louis Phillips.
Excellent. Mr. Phillips, I know this is not your first time coming up to first appearance, but did you have an opportunity to watch the video regarding your first appearance rights?
Yes, ma'am.
And did you understand those rights explained to you?
I understood my right.
Excellent. Mr. McDaniel, tell me, what are we here for this morning?
Your Honor, we have a resolution to this case, 25610MM. I've spoken to Mr. Phillips. He's going to want to enter a plea of no contest to the charge, which is essentially resisting without violence. Understanding he'll be sentenced to 30 days in the county jail. He'll have 4 days jail credit. There'll be a $370 fine. He'll be adjudicated guilty, and that'll resolve this case this morning.
Tell me 4:30, is that what you said?
370 fine.
Yeah, 3.
I have no idea where I got 4:30. Okay, 375. And Dawn, what was the charge is interfering with first responder on duty? Is that what you understand the charge to be as well, Mr. McDaniel?
Yes, Your Honor.
Excellent. Is that a first degree misdemeanor? Second degree misdemeanor?
This one's
Hybrid? Okay,
Yeah.
excellent.
And
Thank
that is-
you.
And that is the agreement with the state, Your Honor.
Excellent. Mr. McDaniel, do you stipulate to a factual basis for purposes of the plea?
Yes, Your Honor.
Mr. Phillips, please raise your right hand, sir. So do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, Mr. Phillips. Mr. Phillips, you can put your hand down. Tell me your full name for the record again, just for the record.
Louis Phillips.
Mr. Phillips, did you hear Mr. McDaniel announce the resolution in this case?
Yes, ma'am.
Is this how you choose to resolve your case?
Yes, ma'am.
Has anyone promised you anything other than what he just said to get you to enter into this plea?
No, ma'am.
Is anyone threatening you?
No one.
Mr. Phillips, do you understand that by choosing to enter a plea today, you are giving up your right to go to a trial where the state has to prove that you did what they say you did?
Yes, ma'am.
Do you also understand that you are giving up your right to present any defenses that you may have to the charge?
Yes, ma'am.
Finally, do you also understand that you are giving up your right to appeal anything except an illegal sentence by this court?
Yes, ma'am.
Are you doing this of your own free will?
Of my own free will, ma'am.
All right. Mr. Phillips, I find that your plea is knowingly and voluntarily entered into after the advice of counsel, and that there is a stipulated factual basis for purposes of the plea. I will now proceed to sentencing unless I hear otherwise from either the state or from the defense. Mr. Phillips, in Jackson County case number 25MM610, I accept your plea of no contest. 1, first degree misdemeanor charge of interfering with first responder on duty. I will adjudicate you to be guilty of the offense and sentence you to serve 30 days in the Jackson County Jail with credit for 4 days that you have already served towards that sentence. I will also impose court costs, fines, and fees in the amount of, guys, is it 370 or 375?
370.
370. Okay. In the amount of $370. Sir, you may work those fines and court costs off while you are in jail. However, if you don't do that, then those will be reduced to a civil judgment if not worked off while in jail. Dawn, will you add that little part about?
Yeah.
Okay, perfect. That's all right. I know you may not have been done. Mr. Phillips, I am required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. Mr. Mitchell, do you have any objection to Mr. Phillips being considered for the trustee program?
No objection, Your Honor.
Mr. Phillips, the court has no objection to you being considered for the trustee program. However, that is something you have to qualify for and apply for at the jail. But if you get into the trustee, you may be eligible for additional gain time off of your 30-day sentence, okay?
Yes, ma'am.
Do you have any questions for me, sir?
No, ma'am.
Is there anything further from either the state or the defense?
No, Your Honor.
No, Your Honor.
All right, Mr. Phillips, I wish you well. Guys, stand by. We're getting the driver's license record in just a sec.
Yes, Your Honor.
Almost literally a sec.
Thank you, Dottie. Appreciate you. Okay, Dawn, will you help me? Tell me what it says. I need you to decipher. You read these much more than I do. I'll repeat whatever you say so that they can hear it. Do you read these, Chuck?
Every now and then, but
Yeah, Dawn's the master.
I can see, I see sometimes.
She has, looks like it mainly her suspensions are FR cancellations.
All financial suspensions, so won't qualify for right? Are you seeing anything other than a financial?
And I knew it was for financial reasons. I got
John, you
suspended.
want us to take pictures real quick? You know what would make me feel much better, John, though? Is if I take pictures of this and send it to you.
Well, I guess my only question, I knew it was financial. I can look that up myself. My only question was, has she ever had a prior DWLSR on the record?
She had one in Jackson County, a driving while license suspended, in 2010.
2010 in Jackson County, what happened then? Was it an?
That's fine.
It was a unknowingly driving while license.
It was an unknowingly.
So it'd be a second degree.
There were
misdemeanor.
points assigned, she said.
Yeah, 6 months probation.
So 2 second-degree misdemeanors max, right?
It'd be a second degree misdemeanor then, Your Honor. 6 months probation.
John, you want us to send you this picture of the driving record?
No, I don't know.
You feel good about it?
Absolutely. Yes, Your Honor.
She had a prior state.
She had a prior state license out of Colorado. I'm just repeating in case you can't hear, Dawn.
Yes, Your Honor.
I don't know what.
Jake, I'm good with the second degree misdemeanor if you're good with it and going ahead and getting it resolved unless you tell me otherwise.
Based on what I've heard today, I'm fine with it being a second degree misdemeanor. And in that case, I think the offer would just be amended to 6 months probation.
Mr. McDaniel, you want a second to speak to her?
No, Your Honor. She's going to enter plea.
All right, fair enough. So tell me, well, hold on. So I've already asked Ms. Capps and told her what she was charged with. Ms. Capps, listen carefully to Mr. McDaniel and tell me if this is what you want to do, okay? Listen carefully.
Your Honor, I spoke with Ms. Cap. She's going to plea of no contest to driving my license suspended, revoked. Understanding she'd be placed on probation for 6 months. That $400 fine. If she gets her driver's license reinstated within 60 days, that fine will be $300. She's not to drive a vehicle without a valid license. And this will resolve this case today. She has signed her plea waiver form with the right to pre-trial and call witnesses.
All right. Ms. Capps, please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. Tell me again your full name for the record.
Jan Renee Capps.
Ms. Capps, did you hear the announcement that your attorney just made about resolving your driving while license suspended or revoked charge?
Yes, ma'am.
Is this how you choose to proceed?
Yes, ma'am.
Has anyone promised you anything other than what he just said to get you to enter
No,
into
ma'am.
this plea? Is anyone
ma'am.
threatening you?
No, ma'am.
Ms. Capps, do you understand that by entering into a plea today, you are giving up your right to go to a trial where the state has to prove the allegations against you?
Yes, ma'am.
Do you also understand that you are giving up your right to present any defenses that you may have to the allegations in the complaint?
Yes, ma'am.
Finally, do you understand that you are giving up your right to appeal anything except an illegal sentence?
Yes, ma'am.
Are you doing this of your own free will?
Yes, ma'am.
All right. Ms. Capps, I find that your plea is knowingly and voluntarily entered into after the advice of counsel. Mr. McDaniel, do you stipulate to a factual basis for purposes of the plea?
Yes, Your Honor.
And I also find that there's a stipulated factual basis for purposes of the plea. I will now proceed to sentencing unless I hear otherwise from either the state or the defense. Ms. Capps, in this case, I accept your plea of no contest to 1 second-degree misdemeanor offense of DWLSR knowingly. I will withhold adjudication of guilt, and I will sentence you to serve 6 months county probation. I will order you to pay court costs, fines, and fees in the amount of $400. However, if you obtain a valid driver's license within 60 days of being placed on probation and show proof of the same, your fine will be lowered to $300. I order you not to operate a motor vehicle without a valid driver's license. Ms. Capps, we see so many people here for no valid DLs, and people don't think these are serious charges, but you could absolutely end up in jail for no valid DL, and I need you to understand that. If you get a no valid DL, or excuse me, a DWLSR again, it could be 60 days here plus a year for the new one, okay? Do
Yes,
not
ma'am.
drive without a license.
Yes, ma'am.
I'm required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. Ms. Capps, what will happen now is you will be released from the jail and brought to the Jackson County Courthouse. At that time, our county probation officer will instruct you as to the terms of your county probation. And there are general conditions of probation that I order you to comply with, okay? Anything else I have to tell you right now? No? All right, anything else, State Defense?
No, Your Honor.
No, Your Honor.
All right, well then, Ms. Capps, I wish you well. And I think that takes care of first appearances, right, guys?
Yes, that's what we got, Your Honor.
All right, thank you. That'll conclude this matter. All right. We'll be in recess.
All right, gentlemen, I'll see you Friday.
All right, friends, good morning once again. Courtroom Files Live, episode 202. This will be our last live of the year, but we will have content for you the rest of the way in this time slot. We'll do best ofs the rest of the week until we start back up next Monday on our first episode of 2026. So I want to do a couple things here real quick. First off, courtroomfiles.com, and I'll drop a link in the chat here in a moment. But this shirt, along with everything else in the Harris County collection, is retiring at the end of this year. So you've got 2 days left if you want any of the Judge Fleischer inspired items that we have over there. But after midnight tomorrow night, when we ring in 2026, that collection will be retired. So I wanted to make you aware of that. So if there's anything you want, get over there. Members, you have a larger discount. Everybody gets 10% off right now, though, with a code that's displayed on the website. So again, I'll drop a link in just a minute. But I want to go to Lenawee County, Michigan, to Judge Olsaver's court, and this is a hearing that actually happened about an hour ago. So we're going to go in the Wayback Machine a little bit. But this was in regard to a defendant named Dale Warner. And this is a big case that's going on over there. It's set for trial in the new year. This is a pre-trial hearing that happens. But Dale Warner is accused of killing his wife and hiding her body in a chemical tank on their property. The alleged murder happened in April of 2021, and it was only in 2024 where they discovered her body in this chemical tank. So it's kind of a big deal in southeastern Michigan, southeastern lower there. So I wanted to go to this hearing and check it out and get up to speed, because it might be a trial we pay attention to next year, but we shall see. Anyways, let's go to Judge Olsaver's court.
Here we are.
Okay, this is file 24-21841-FC, People of the State of Michigan versus Dale Warner. We are here today for hearings on several motions. We are proceeding today partially in person and partially by video conference. First, can I have the attorneys place their appearance on the record, beginning with Ms. Wise.
Good morning, Your Honor. Jackie Wise on behalf of the people.
Good morning, Your Honor. Mary Chartier on behalf of Dale Warner, who is participating via Zoom, as am I.
All right, and as I indicated, we do have several motions today, one from the people and several from the defense. So let's start with the people's motion to compel discovery.
Your Honor, I received a witness list from defense last Monday, and I did send a follow-up email requesting contact information from 3 people. And I know Ms. Chartier said she would get that to me. So I expect that to be coming. Other than that, I believe I have what I need from Ms. Chartier.
Okay, so it sounds to me that you don't feel any further order at this point is necessary. Is that?
I would just ask Ms. Chartier to confirm that she is going to be sending me that contact information.
I will definitely this week. So Ms. Wise requested the contact information to a paralegal. She emailed the paralegal who had emailed the witness list to her. Because of the holidays, she's been out. I have not had a chance to check her email yet today, just because the hearing started at 8 a.m., but I will. If I don't get it to Ms. Wise today, I should be getting it to her tomorrow. But I don't see any reason why I can't get the phone numbers to her today.
I'm satisfied, Your Honor.
Okay. All right, that leaves us then with the defense motions. Ms. Chartier, I'll let you start wherever you would prefer.
Thank you. So we filed 4. I won't be repetitive of what's in the brief. I'll just hit some of the highlights. So the first one is the motion for additional peremptory challenges. As this court is aware, there are 12 each that each side will get because this is a life offense. When courts have granted this in the past, while courts have the discretion to only give one side additional peremptories, if this court were inclined to give the defense additional peremptories, we certainly don't object if the government would seek more as well. The good cause here, which is required under the statute, quite frankly, is the significant media coverage as well as the significant community opinion that appears to exist to a large part to Mr. Warner's detriment. So I know when we brought the motion for a change of venue, we articulated that in the Justice for D page, there had been communications or posts about being a stealth juror, and that's still our concern. The concern is that people will say the right things in order to at least be able to be seated on the jury. And as this court knows, it's not only about what people say, but it's also about how people say it. So someone may say, well, yes, I had this opinion, but I can be fair and impartial. That's really not enough to be a seated juror in this case. And while that may not rise to the level of cause, depending on what the court's determination is, it certainly would indicate a need for a peremptory challenge to us. And obviously each juror is an individual, and we would certainly delve into what they have to say, what their thoughts and opinions are. But my concern is that people may say the right things to be seated, and then with only 12 peremptories, we cannot protect Mr. Warner's constitutional rights.
What?
Your Honor, this court, I believe, has set it up for approximately 700 potential jurors to be brought in and has allowed for individual juror questioning. I believe it's up to the parties in the court to determine, yes, while some jurors may say that they are able to be fair and impartial, I believe that further questioning will get us to whether they can actually be fair and impartial. And I believe the court has enough things in play to weed out those jurors. So I would ask the court to deny this motion at this time.
Ms. Chartier, I'll give you an opportunity at rebuttal if you care for it.
The only thing I would ask is if the court is inclined to deny the motion, I would ask the court to deny it without prejudice so that if the need comes up during jury selection, we can renew that request with the court. And I'll be frank, a lot of it depends on some judges are much more strict with challenges for cause than others. And so a lot of it depends on where we land with that during jury selection. We've had additional peremptories before and we haven't had the need to use them because courts have been more liberal with challenges for cause and vice versa. So if the court is inclined to deny, I would just ask it to be without prejudice so we can renew. Thank you.
Okay, it is clear that there has been a large amount of media and social media coverage and interest in this case. That has been the topic of prior hearings. In response to that, the court has called in a significantly larger number of jurors than it would normally call in even for a capital case. I think that additional number of jurors, in my mind, supports the increase in peremptory challenges. I do think there's a concern here that first, that we're likely to excuse a large number of jurors for cause, but there has been some indication that there are some people who may be interested in trying to get on the jury when they shouldn't be. That social media post has previously been provided to the court, and I think we need to take that concern seriously. I do think that supports a finding of good cause to increase the number of peremptory challenges in this case. And as I said, I'm more comfortable doing that given that we have a significantly larger normal number of jurors that will be in the pool. So at this point, I would grant that motion and increase the number of peremptory challenges for each side to 18 from the 12 they would normally get, so a 50% increase in the number of peremptory challenges.
Thank you, Your Honor.
All right, which motion would you like to address next?
The jail calls, please. So I'll wait till the court's ready. Sorry.
Go ahead.
Okay. So the court is well aware that we had filed a motion to preclude the use of 2 jail calls or any other jail calls that the government sought to admit, and the court denied that. The court did grant our request for all of Mr. Warner's jail calls to be sent to us. We have gone through those, and I will tell you I was surprised when I was listening to one and I heard voices familiar, and then I realized it's my voice, Mr. Head's voice, voices from our office, voices from the Head Murphy law firm. And as I went through, I thought, well, maybe that was just a mistake. Someone happened to record that by mistake, and it wasn't a mistake. Then when we had the hearing the last time in court, Detective Drurior admitted that he is listening to attorney-client phone calls on the jail line. And that was extremely surprising to me, because when there's a wiretap, for instance, in federal court, you frequently will have wiretaps on clients' phones. The order always indicates to not listen to privileged calls. And so when you get the calls from the government where they're wiretapping your client's telephone calls, when you get a privileged call, either with a doctor or more frequently with their lawyers, you'll hear it say minimize. And then the rest of the call was never listened to. It was never recorded. Here, not only were the calls recorded by the jail, but then they were turned over to the police, and then they listened to all of them with no attempt, according to Detective Drurior, to stop listening once they realized they were attorney-client calls. He indicated he was on the treadmill, and then he just kept listening. And some of those calls go 12, 15, 20 minutes long. It was shocking to me how nonchalant he was about listening to attorney-client communications between Mr. Warner and myself and the Head Murphy law firm. He's working out. It's not like he's bedridden. He could have jumped off the treadmill and moved on to the next call. He chose not to do that. And then I was even more surprised, quite frankly, when I got the prosecutor's response that they don't think there's anything wrong with that. And presumably, those calls have been turned over to the prosecutor. I was actually operating, probably mistakenly, under the assumption that those calls were not turned over to the prosecutor. But based on their response, they very well may be. So for the number of years, essentially, or certainly significant number of months that Mr. Warner has been locked up, people have been listening to his attorney-client calls. I mean, it has an unbelievable chilling effect. Mr. Warner called our office. I said, tell him I'm not going to take the call. I'll visit with him instead. But then I'm quite frankly concerned about, if I do a video visit with him, are they now recording that and turning that over? If I meet with him in person, is someone flipping a switch and listening to the communication? The lack of concern for respecting privilege is quite frankly chilling. But what's even more concerning is the prosecutor just going along with that. If the jail records the calls, I don't think they should. But regardless of that, even if they do, once the police know that they are listening to an attorney-client call, they should stop listening, not just double down, listen to it, and proudly state on the stand that they are listening to it. I struggled with, quite frankly, what's the remedy here? I've never had this happen in all my years. I do know colleagues around the country who've had this happen, but I always thought, well, that's such an anomaly. I can't imagine anyone in Michigan who I've ever worked with doing that. Well, now I certainly can imagine that because it's happened to Mr. Warner. What is the remedy here? I mean, the remedy at a minimum is an order saying stop listening to Mr. Warner's attorney-client calls. But does that go far enough? I leave it to the court's discretion. I mean, remedies can range from dismissal of the charges to sanctions to jury instructions. The damage, though, is done here. So it's so difficult to fashion a remedy to talk about you should never have been listening to his attorney-client calls from the beginning, which is such a basic concept that, quite frankly, I was shocked I had to file the motion, and then I was shocked at the response that I received.
Weiss.
Your Honor, in this case, the attorney has the ability to go to the jail and meet with her client. She has the ability to set up her phone number with the jail to have that protected conversation. But to say that she's shocked by the fact that they were being recorded, I have never listened to any of her attorney calls. Nobody's ever called me and said, oh, guess what he was talking about with his attorney. So before this motion was brought, when Ms. Chartier brought it up with me, I didn't know these were being recorded. However, after I got this motion and researched this, I went back and listened for numbers that I didn't recognize. One of the calls, all of the calls say, this is a free call from Dale, an inmate at the Lenawee County Jail. To accept this call, press 0. To refuse the call, hang up or press 1. This call is from a correction facility and is subject to monitoring and recording. Thank you for using GTL. On one of those calls with the number I didn't recognize, as soon as the called party answered, Ms. Chartier responds, Dale, hi. So to say she had no notice that those calls were being recorded is without merit, Your Honor. And the case law is very specific that this is not a confidential communication when they waive the privilege based on that message that was on the phone.
Thank you. So I spoke to Mr. Warner. He indicates that there is not an option for him at the jail to segregate out attorney-client privileged calls. Yes, it says the call is recorded. Obviously, now Ms. Wise has listened to my calls if she knows I say, hi, Dale, on it. Whether the jail records the call for security purposes, which the court has already deemed that they can, but then the police and prosecutor listen to those calls are two separate things. There is no security interest for the police to listen to Dale Warner's calls with his lawyers. And I would ask at a minimum for an order telling them to stop doing it. Yes, we can go visit our client in jail, but they also have phones for a reason. And the hours where we can visit our client are restricted because of what the jail has to accomplish. No one is complaining about that. Jails have restricted hours all the time. But sometimes you need to communicate with your client via phone. And the fact that the government thinks that the police can listen to it at will is extremely concerning.
So, Ms. Wise, there is a method by which Ms. Chartier could have her calls not be recorded by the jail.
Absolutely. I confirmed that with the jail captain when I received this motion.
And how would she go about, or Mr. Warner go about doing that?
They need to get with somebody at the jail, a jail sergeant, the lieutenant, the captain, and provide that attorney phone number that they have to exclude from those phone calls. They have to confirm that that's an attorney, then they provide it to the GTL, which will then exclude it from any of those recorded conversations.
All right.
Who is the, I'm sorry. May I ask who is the jail captain? Because when I spoke to Mr. Warner, I had asked him that specific question and he had indicated that there was no method for him to segregate out attorney phone numbers. Some jails have that method, other jails don't. It generally comes from the client and then it's confirmed with the law firm. So Mr. Warner said that that was not an option. If it is an option, I'd like to make sure I know who is indicated that it is an option. So may I ask who the jail captain is who you spoke with?
Absolutely, Captain Randy Casey.
Okay, thank you.
All right, with respect to any request for a remedy or having listened to calls up until today, I think that the case law is clear and that it supports Ms. Wise's position. The people have cited to an unpublished case of People versus Miller. I do recognize that it is unpublished and therefore it's not precedentially binding upon this court. However, I do find the logic in that case to be sound and compelling. I think it appropriately states the law, and it is based on People versus Campo, which is a published case by the Michigan Court of Appeals, which sets forth the same principle in a slightly different context. And that is that where a person knows that other people are listening to a conversation, they have waived the attorney-client privilege, and I think that is what has happened here. There doesn't seem to be any dispute that the calls between Mr. Warner and his attorney came with a recorded message at the beginning of each and every call that advised both sides in that call that the call was being recorded, and so that other people were listening in. Having proceeded with the call after that, the confidentiality at that point has been waived, and there's no violation by the people listening to that call. Because again, the element of confidentiality does not exist in that context. So I would deny that motion. However, I do think we have established a process by which Ms. Chartier and Mr. Warner can communicate by telephone without having calls recorded and have an expectation of confidentiality in those calls going forward.
Thank you, Your Honor.
Okay, and which motion would you like to move to next?
The Daubert motion on Michelle Ponchke, who is the paint analyst.
All right, go ahead.
Thank you. This court is well aware, I believe, of the standard required by Daubert. So essentially, the testimony of the proposed expert witness must be relevant. It also must be scientifically valid. And in Craig versus Oakwood Hospital from the Michigan Supreme Court, there has to be a general acknowledgement of the legitimacy of the testing. The testing has to be grounded in scientific principles and methodologies, and the validity of the testing cannot be based on a subjective belief or unsupported speculation. And essentially, it has to be reliable. The burden of proof rests on the government to prove that it is admissible, and the expert, through the government, has to establish the reliability of the principles and methods to draw a conclusion regarding the particular matter to which the expert testimony was directly relevant. In Gilbert, which is another Michigan Supreme Court case, the court laid out 4 separate criteria, and we have none of it in this case. The data underlying the expert's testimony must be substantial and trustworthy. We don't know that in this paint analysis. The manner in which the expert interprets and extrapolates from the data is reasonable and sound. We don't know that. The opinions based on the data express conclusions reached through reliable principles and methodologies. We don't know that. And the expert is qualified to provide opinions that are in the scope of the individual's expertise. We don't know that. We don't even know what her credentials are to examine paint. So we don't have any of the underlying foundation to even let in testimony about pain analysis. But even beyond that, when we get to the relevancy of it, the lab analyst is essentially saying, well, we looked at some paint on Mr. Warner's property. Some of the samples match, some of the samples don't. It could have come from the paint on the property, or it might not have. And then to put it into context, which the court knows, they're analyzing the upper layer of the paint on the tank where Ms. Warner's body was found. So the conclusion of the analyst is it could have come from the same source, or it could have come from a different source. That's certainly not relevant because an individual source can't be determined, or cannot even be determined with any sort of statistical probability, so that we know, okay, how many cans of this paint are actually produced in a year? How many of it are sold in Michigan? Is this common on farms? It sure seems like it would be. So for all those reasons, I don't believe that Ms. Ponchke should be allowed to testify, because none of the basis of Daubert has been established here. If the court obviously disagrees with me, then I would ask the court for a Daubert hearing in which we could question Ms. Ponchke, as well the government can put their proofs on, to determine if the science is really valid here and if it was applied reliably to the facts of this case. Now, I recognize we have trial coming up in a month or a little less than that, but there certainly is ample time for a Daubert hearing. I don't think that it would be a lengthy process. We also have the roughly 2 weeks of jury selection if we needed to, try to fit something in there. So I would ask the court to grant my motion. Thank you.
Your Honor, as to the relevance of the testimony about the paint, it is relevant because it goes to means and opportunity. Under People v. Hall 433, Mich. 573, and People v. Houston 261, Mich. 463. Both of those cases involved defendant being arrested, subsequently in possession of a firearm that they weren't able to say was the firearm used in the crime that was committed. However, it was similar in kind to which the crime was committed. And the court said those were admissible because they go to means and opportunity. I've submitted the lab report with my response to the court, so the court can see that, again, some of the paint samples did not match, some of them did. I think that it goes to the weight the jury decides to give it, not to its admissibility. It is relevant. However, if the court would want to grant the Daubert hearing, we would have no objection to holding that hearing.
Anything else on this one, Ms. Chartier?
No, Your Honor, I say no and then I keep talking. But the only thing is, I think if the court is not going to exclude, I think a Daubert analysis will get to at least the major concerns that I have, with the exception of the relevancy. But again, we don't even know how the science was conducted here. And so a Daubert hearing will at least help us get there.
Okay, the way that the court establishes whether or not an expert can testify in case is to conduct a Daubert hearing. I do think that's completely appropriate in this case before the court makes a decision. So I would ask you to schedule that. Perhaps when we're done here, you can contact Sierra Francis offline. And I think we should have some time available before the trial begins in order to get that done.
Thank you, Your Honor.
Okay, I think that leaves only the motion for a spoliation instruction.
Thank you, Your Honor. I would ask for that instruction to be given based on the testimony of both Detective Drurior and retired Detective Singleton that text messages were destroyed. We know that they did not record every aspect of interviews. We know that they didn't necessarily record even some interviews or conversations they had with people, or even log it down. When I was questioning both Detective Drurior and Detective Singleton, their response was, well, we didn't preserve text messages, but we don't know how they got deleted off our phone. It may just be a policy or procedure of MSP where things are deleted a year after they're on the phone, whatever it may be. That seemed questionable to me, but that was their testimony. But then we received typed text messages from the government that Greg Hardy had purportedly given to them. So essentially, rather than taking screenshots of his phone or rather than turning his phone over so that there could be a download, he typed messages during a particular time frame. Not all the messages on his phone, but just the ones during the time frame that he believed that Detective Drew sent his messages over. When we compared the messages side by side, it was clear that the destruction wasn't based on some policy or procedure that Detective Drew was unaware of, because there are 3 messages that Greg Hardy turned over that he typed. So purportedly they are real messages that Detective Drew did not turn over. But the other one that is significant is Detective Drew had turned over a screenshot of a message exchange between himself and Mr. Hardy. But when Mr. Hardy typed up that same exchange, there were sentences missing, and this would be within the 1-year time frame. So there's literally no reason why that aspect of the message wouldn't have been turned over, other than Detective Drew decided he didn't want to turn it over. He either deleted it from his phone or he just chose not to turn it over. That is bad faith 100%. There is no other way to frame that. It is an intentional withholding of evidence from the defense. And the government's notion through the police seems to be, well, we determine what's of evidentiary value. And so if we don't think it's of evidentiary value, we can destroy it. We can delete it. It doesn't matter. But it's the defense's right to see evidence. It's the defense's right to determine if evidence is valid or not valid. And we cited a quote in there from Jenks versus the United States, from the United States Supreme Court, which aptly articulates our position on this, because only the defense is adequately equipped to determine the effective use for purposes of discrediting the government's witness and thereby furthering the accused defense. The defense must initially be entitled to see the discovery requested to determine what use may be made of them. Justice requires no less. So it is not for Detective Drew to determine, well, these messages don't matter, I'm going to delete them. These messages don't matter, I'm not going to turn them over. He has a job, he swore an oath to turn over evidence. And it's not just his determination of what has evidentiary value. And we know from the messages that were turned over that they do have evidentiary value to the defense. So I would ask for an instruction to be given to the jury, because we cannot argue that the messages were exculpatory that haven't been turned over, because we haven't seen them, because they have been destroyed. But we do know that they were intentionally destroyed. And so in that case, we don't have to show bad faith, or excuse me, it is not a matter of good or bad faith, which it is with exculpatory evidence. Here, we have to show bad faith, and I believe that we have, by the intentional destruction and by the intentional destruction in omission in this 1-year time period where Greg Hardy has proven that Detective Drew did not turn over everything that was on his phone. Thank you.
The due process clause does not impose an undifferentiated and absolute duty to retain and preserve all material that might be of conceivable evidentiary significance in a particular prosecution. Here, Detectives Dreher and Singleton both testified that it was their common practice and procedure to take those messages that they believed were of evidentiary value, document them, and then delete the messages. Detective Dreher is the one that asked Greg Hardy if he had a copy of their text messages to provide to the defense. That can't be said that Detective Dreher acted in bad faith or that Detective Singleton acted in bad faith. Based on the law that I provided the court, I'd ask the court to deny the motion. Based on the very definition of spoliation, Your Honor, there was no intentional destruction of evidence with the purpose of rendering it inaccessible or useless to the defendant. Therefore, they're not entitled to the spoliation instruction.
So that doesn't seem to match up with the police report that we got in the text messages. So according to the police report, Greg Hardy provides a folder of documents that contain text messages. So there's no indication that he asked, that Detective Dreher asked for them. The police report says Greg Hardy called me on 12/5/25. I asked Greg about the documents messages that he provided. He stated he provided the messages for the time frame that were in question and has additional messages on his phone. Greg stated it took great effort to document them and it was not an easy process. And I believe that in another email or text message exchange, Greg Hardy indicates that he's been trying to get in touch with, I believe it's Detective Drew, but nobody is responding back to him. So the notion that he asked for the messages seems to be belied by the evidence that they've turned over themselves. So again, so this is from Greg Hardy on December 2nd, 2025. It's an email from Greg Hardy to Jackie Wise. I have made a copy of text messages that you had requested previously between Drew and I for the time period that apparently is in question. I have left numerous messages for you and Lee with no response. Do you want the text messages or not? So Detective Drew isn't asking for those messages. The prosecutor is. So it's not like Detective Drew is trying to fix this problem that he created. If anything, the prosecutor is trying to, but then Greg couldn't get a hold of anybody. So he came in with at least partial messages. But the messages show that Detective Drew intentionally destroyed evidence.
All right, I'll touch on Brady briefly since it was briefed, although I understand the arguments to be that defense is not pursuing a Brady violation at this point. But Brady versus Maryland held that suppression by the prosecution of evidence favorable to an accused upon request violates due process, where the evidence is material either to guilt or punishment, irrespective of bad faith. In order to establish a Brady violation, evidence is favorable to the accused when it is either exculpatory or impeaching. In this case, there isn't any evidence that the deleted text messages were either exculpatory or impeaching. And therefore, the defense cannot establish a Brady violation. Arizona versus Youngblood established the rule that where potentially exculpatory evidence is permanently lost, a defendant must show bad faith on the part of the police in order to establish denial of due process. United States Supreme Court in Youngblood indicated an unwillingness to read the fundamental fairness requirement of the due process clause as imposing on the police an undifferentiated and absolute duty to retain and preserve all material that might be of conceivable evidentiary significance in a particular prosecution. Rather, the Supreme Court stated, we think that requiring a defendant to show bad faith on the part of police limits the extent of the police's obligation, both limits the extent of the police's obligation to preserve evidence to reasonable bounds and confines it to cases where the interests of justice require it, i.e. those cases in which the police themselves, by their conduct, indicate that evidence could form a basis for exonerating the defendant. The evidence before the court at this point is that certain text messages between detectives and witnesses were deleted. The officers both testified that they preserved anything that they determined to be of evidentiary value and did not preserve other texts that dealt with things like logistical issues and setting up meetings. They both testified that this was consistent with their training and experience. For example, the deleted text messages referenced in Mr. Warner's motion dealt with contacting the medical examiner's office regarding an update. This appears to be exactly the type of communication that the Youngblood court was referring to in not imposing an undifferentiated and absolute duty to retain and preserve all material that might be of conceivable evidentiary significance. I don't think it's been established here that the deleted text messages are even potentially exculpatory, as both detectives testified that they preserved everything that they believed had any evidentiary value. And there's been no indication that the police, by their conduct, have indicated that the evidence could form a basis for exoneration. Assuming arguendo that the evidence is potentially exculpatory, because some can take a broader view that we can't possibly know what we don't know or what the evidence is. it has not been established that the police acted in bad faith in deleting the text messages. The only evidence that they acted consistent with their training and experience in exercising discretion to preserve the items which they believed had some evidentiary value and not preserving the items which they did not believe had any evidentiary value. And so I don't think that there has been a Youngblood violation either. And so I would deny the motion for the spoliation instruction.
Thank you, Your Honor.
I believe that's all the motions that we had on the docket for today, unless I've missed some.
No, there are only two other items, if I may briefly address them. Just updates to the court more than anything else. So the court had requested jury instructions by January 7th. Ms. Wise and I have been communicating. I've sent her information. She sent them to me. We should be able to, I think, probably finalize anything going back and forth. And so the plan is to get those filed no later than Monday. So we would overnight them, and that way the court would have them. And then as it relates to witnesses, we received an amended witness list from the government last night. They took off one witness. We are adding that witness onto our witness list. So we will also overnight a copy of it to the court. We had put a general line in our witness list, essentially any witnesses on the government's witness list, but just to make sure it's very clear on who's being called by what party. We'll also make sure we add that to the proposed jury instructions, that we have a nice alphabetical list of the witnesses. So I just wanted to mention those two things. We are working on making sure that we comply with the court scheduling order.
Okay, in addition to emailing in addition to overnighting your jury instructions, can you email those as a Word document to Sierra so that she can start to put those together?
Yes, I usually do, even if it's not requested, because I think it has to be so much easier than retyping everything. So yes, I will do that.
Okay. All right. Anything else that we need to address, Ms. Wise?
No, Your Honor.
Okay. I do owe you decisions on two motions the court previously heard and took under advisement. And since I have you here today, I think I'll just do that on the record rather than write an opinion. The first of those was the admissibility of some photographs that the court has now had an opportunity to review. Those were challenged by the defense. The first thing the court has to determine is that the photographs are relevant. Relevant evidence means any evidence having any tendency to make the existence of any factors of consequence to the determination of the actions more probable or less probable than it would be without the evidence, and that comes from MRE 401. The first thing the court has to determine is the materiality of the proposed evidence. In other words, whether the evidence was of consequence to the determination of the action. Materiality does not mean that the evidence must be directed at an element of the crime or applicable to the offense. There must at least be in issue in the context of the case. In a criminal case, all elements of an offense are in issue when a defendant enters a plea of not guilty, which is the case here. The prosecution, therefore, has the burden of proving every element of the crime beyond a reasonable doubt, regardless of whether the defendant specifically disputes or offers to stipulate to any of those elements. The claim that evidence goes to an undisputed point is inadmissible has also been rejected in criminal cases. For example, People versus Mills, 450 Michigan 61, People versus Neaton, 264 Mich 134, and People versus McPherson, 323 Mich 438. Mr. Warren in this case is charged with open murder and knowingly and intentionally removing, altering, concealing, destroying, or otherwise tampering with evidence. Photograph 1 in this case shows what the body looked like upon arrival to the medical examiner. It was covered in a white bag or tarp. that must have been placed there by law enforcement because it does not appear in the earlier photos when the body was initially discovered. For that reason, I don't think that photograph 1 bears on any fact that is an issue in this matter, and I don't find that photograph 1 is relevant, so I would exclude that one. Photographs 19, 20A, 20B, 2A, and 2B all depict Ms. Warner's body wrapped in a blue tarp as it was discovered and then removed from the tank. 20A and 20B are photos taken at the scene. 2A and 2B are photos taken at the medical examiner's office. Those photos all contain essentially the same information. They depict the state of Ms. Warner's body as it was found. I think these photos speak directly to whether her body, which is evidence in this case, was concealed, altered, or otherwise tampered with, which is an element of the tampering charge. Photographs 3, 4, 5, 6, and 7 depict the state of Ms. Warner's body upon being unwrapped from the blue tarp. They depict additional tape around portions of her body. These again speak directly to whether the body was concealed, altered, or otherwise tampered with, which is an element of the tampering charge. Photographs 8 through 17 depict the injuries that Ms. Warner suffered. That information speaks to the cause of death and to intent, which are both elements of the open murder charge. Therefore, I found those photographs to be material to this case. I'm going to hold off on photograph 18 because I have some additional questions about that. Next, the court has to determine the probative force of the evidence, whether the evidence makes a fact of consequence more or less probable than it would be without the evidence. Any tendency is sufficient probative force. As I've stated, the people must prove beyond a reasonable doubt that Mr. Warner caused the death of Ms. Warner and that Mr. Warner intended to kill Ms. Warner. These pictures, the pictures of her injuries, make it more probable that Ms. Warner was intentionally killed. And so I do think those photos have probative value. People must also prove that Mr. Warner removed, altered, concealed, destroyed, or otherwise tampered with evidence. And as I've said, Ms. Warner's body is evidence in this case. The pictures of where the body was located and the condition upon being found make it more probable that her body was removed, altered, concealed, or otherwise tampered with. And so I do find that the photographs have probative force. In determining that the photographs are relevant under 401, or after determining that the photographs are relevant under 401, the next question is whether the evidence must be excluded under 403. Under MRE 403, relevant evidence can be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. All evidence offered by the parties is prejudicial to some extent, but the fear of prejudice does not generally render evidence inadmissible. It's only when that probative value is substantially outweighed by the danger of unfair prejudice that evidence should be excluded. Photographs are not excludable simply because a witness can orally testify about the information contained in the photographs. Photographs may also be used to corroborate a witness's testimony. Finally, gruesomeness alone need not cause exclusion. Photographs that are merely calculated to arouse the sympathies or prejudices of the jury are properly excluded, particularly if they are not substantially necessary or instructive to show material facts or conditions. If photographs which disclose the gruesome aspects of an accident or a crime are not pertinent, relevant, competent, or material on any issue, in the case and serve the purpose solely of inflaming the minds of the jurors and prejudicing them against the accused, then they should not be admitted. However, if photographs are otherwise admissible for a proper purpose, they are not rendered inadmissible merely because they bring vividly to the jurors the details of a gruesome or shocking accident or crime, even though they may tend to arouse the passion or prejudice of the jurors. Generally, also, the fact that a photograph is more effective than an oral description and to the extent calculated to excite passion and prejudice does not render it inadmissible in evidence. That comes from People versus Eddington 387, Mich. 551. The photographs at issue in this case clearly show some gruesome aspects of the crime. They are, however, pertinent, relevant, competent, and material in that they directly address elements of the alleged crimes in this case. This is a proper purpose that goes beyond simply inflaming the minds of the jurors. The photographs have significant probative value that bears directly on elements of the alleged crimes. That significant probative value, I don't believe, is outweighed by any danger of unfair prejudice in this case. The court may also exclude evidence where it is cumulative. Photographs 20A, 20B, 2A, and 2B all depict Ms. Warner's body wrapped in the blue tarp. There does not appear to be any additional value or information to be gleaned from a review of all of them, and therefore I would limit the people to one of those 4 photographs, with the other photographs being admissible. I did say earlier that I was holding off on photograph 18, which is the photograph of Ms. Warner's right hand with some jewelry on it. And I was holding off on that, Ms. Wise, because I wasn't certain what the purpose of that photograph was or how it was to be used in evidence in this case.
Your Honor, one of the stories that the defendant told early on was that she's always wearing a bunch of jewelry and this would make her a target. Basically some stranger took her. So that would go to refute that argument, Your Honor.
Okay, Ms. Chardy, is there anything further you want to say on that issue?
So the issue of that would be Mr. Warner was asked repeatedly by law enforcement to try to determine where Ms. Warner was. So what does he think happened to her? What could have happened to her? When listening to the interviews, Detective Greca actually came up with ideas that Mr. Warner shut down and said, no, that's not likely, that's not likely. So trying to answer law enforcement questions, and then the fact that she only has 1 ring or 2 rings on her hand, when he indicated that she does like jewelry, certainly is not relevant in terms of showing the photograph. The other thing is I think all of her children will admit she liked jewelry. And I think the detectives looking at the amount of money she spent at the jewelry store will affirm that. She spent a large amount of money on jewelry, which is fine. She liked jewelry. That's not a reason to admit a photograph of a hand from an autopsy photo with a ring on it.
What I'm going to do is hold off on making a ruling on that and wait to see how the evidence comes in at trial to be able to make a determination on whether or not there's relevance there.
Thank you. May I just confirm, so number 1 is excluded, 18, the court is holding off to determine what the testimony is, and then the government has to pick 1 photograph from 20A, 20B, 2A, and 2B?
That is correct.
Okay, terrific. Thank you.
Okay, and then the last issue was some statements about the purchase and use of a lake home and the admissibility of those statements. Under Emory 8033, which is the then existing mental, emotional, or physical condition exception to the hearsay rule. That rule allows statement of the declarant's then existing mind or emotional, sensory, or physical conditions such as intent, plan, motive, design, mental feeling, pain, or bodily health. In this case, we're talking about statements made in 2018 or 19 about the purchase of a lake home. I think that these statements are remote in time from the alleged crime in April 2021. While they do speak to Ms. Warner's plan to use the lake home as a safe house when the Warners had a fight, this was a plan that she had 2 to 3 years before the alleged crime. Her plans during that time, I don't think have significant relevance to the allegations in this case. Even if there is some relevance, I think that that relevance would be outweighed by the danger of unfair prejudice to the defendant, that the jury may consider it more as character evidence that since he behaved in a way that made her leave the home in 2018 or 2019, that he must have behaved in a similar or violent fashion in 2021. So I would exclude those statements from 2018. And so I think that brings us up to speed with all of the motions that were filed today or were previously pending.
Correct, Your Honor.
That's correct.
When Ms. Charday was asking for clarification, I didn't hear her bring up the other one, so I just wanted to clarify in the photographs that photographs 3 through 15 and photograph 19 are admissible. And I apologize if you said that and I didn't hear you.
So I had 3 through 17 being admissible, 1 of 19, 20A, 20B, 2A, and 2B, and then reserving a decision on 18.
Thank you, Your Honor.
All right, I think we're all set for today. Thank you.
Thank you, Your Honor.
Okay, friends, just to make sure everybody's up to speed, because I know a bunch of people joined in kind of in the middle there. So these were pretrial motions that we just heard from the defense, and the defendant's name is Dale Warner, and this is in Lenawee County, Michigan, so southeastern lower. He is accused of killing his wife and hiding her body in a chemical tank. Now, she disappeared, the wife did, April 25th of 2021, and her body was not discovered until 2024. And at the point she had been discovered, she had already been legally declared dead. So a lot of time passed between her disappearance and the finding of her body. I was aware of this case before this hearing this morning, but I saw it a few minutes before we went live, and it intrigued me because of the different things that were being tackled, including the idea that the jail calls that the defense attorney was having with the defendant were being listened to, admittedly listened to. So there's a lot of stuff going on here. So if you caught that in the middle, you can either go back and watch, or I'm 99% certain this is going to be a standalone video tomorrow, so you'll be able to catch it then as well. And I know there was a couple of requests in the chat to follow this going forward. We'll do our best. Long trials don't really fit the format of the morning show here, but we are adding a 4th hour starting January 12th. And one of the things that I want to do in that hour is have discussion on cases that we're not necessarily covering in the previous 3 hours. The 4th hour will be different from what we do in the other 3. It'll be a lot more talk and discussion and stuff like that, I think. But in that venue, in that 4th hour, I think is where we'll be able to follow this type of case. So that's what we're going to try to do. Anywho, let's go Let's go down to Ohio. Let's see what's going on with Judge Collada.
Versus Silvana Vlasic, case number 25 CR 000-829. We were 39, sorry. We were last here on December 1st, at which time the defendant entered a written oral plea of guilty to count 1 criminal damaging, a misdemeanor of the 2nd degree in violation of 2909.06A1. Count 2 vandalism, a felony of the 4th degree in violation of 2909.05A. And count 3 aggravated menacing, a misdemeanor of the 1st degree in violation of 2903.21. At that time, both defendants and the state indicated that we had a joint recommendation for 8 months in prison. The case was then referred for a pre-sentence report and investigation and victim impact statement. We are here today for purposes of sentencing. Defendant is present with his counsel, Mr. Corey Hinton.
Mr. Hinton, any reason not to go forward with sentencing?
No such reason, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. As outlined by the state in the instant case, there were 3 charges that guilty pleas were forthcoming on. 2 of those charges were misdemeanors. The felony was a lower level felony in the grand scheme of things. However, in this particular situation, although I normally ask for community control in a situation where there's an F4, we're not making that request. My client has been in the jail for some time now, 224 days. It's certainly given him an opportunity to reflect, and I know you hear that a lot, but in the pre-sentence report he did indicate how this situation divided his family up. He made a decision out of anger and destroyed his sister's home. He had been staying there, had made some improvements to the home. I think it was a little bit of a tough legal concept for him to grasp as far as how everything works out. Even if you put improvements into a home, if you're not the owner and there's some sort of offset for the rent, that that's not your property to destroy. I know there's other things that were separate and apart from that, but a lot of emotion going in, especially when there was a lot of money on our end spent to put in these improvements. So just a very bad situation, but I think the positive out of all this is my client did want to resolve this, avoid any inconveniences to any of the witnesses that would have to travel for trial. I think ultimately, looking at the pre-sentence report, I think there was some remorse shown with him indicating that he just spun out of control because of emotion in the situation. I've had subsequent conversations to him. He certainly understands that what he did was a crime, what he did was wrong. And as a result of that, Your Honor, we are asking that the court adopt the joint recommendation. I know both parties spent a lot of time on this case and in crafting that recommendation. We understand that you have the ultimate decision when it comes to sentencing, but we'd certainly ask you to put a lot of weight on that, Your Honor. Thank you.
Thank you. Mr. Blanchard, you have the right to address this court before your sentence. You can say anything you want. Is there anything you want to say?
I'm sorry, Your Honor. I do apologize. I understand that what I did is wrong. And this was the lowest point of my life. I'm 40 years old, and I've never in my life thought that anything like this would ever come, especially now with my family. I think about it every day. Everything that I put my family through, and it's hard. It's been hard on me, and it's been hard on my whole family, my brothers and sisters, and everyone that's been involved. I want to apologize. I want to let them know that this this is not who I am. It was a spur moment, I guess. It was just something that, I don't know how to say it, but it just exploded in 1 second. You know, it was a bad day for me and for everyone involved that day. But I'd like you to know that I'm not like that. I'm not that type of person. I don't go around and destroy stuff. I am sorry about what happened that day. I would kind of like this to be over with and move on. I am asking for forgiveness, though. That's,
Anything else you'd like to say? You don't have to, but I just want to make sure you said everything you want.
I'm sorry.
Thank you. Mr. Hinton, anything else on behalf of the defense?
Your Honor, I would just reiterate, he indicated that he's 40 years old. This was the lowest point in his life. And I think that's reflected in his lack of criminal history. So when he says this is an isolated incident, even though it was a big incident, I do think that his lack of a criminal history tends to support that. Thank you.
Thank you. One moment, please. Ms. Linden for the State of Ohio.
Thank you, Your Honor. Your Honor, in this matter, as Mr. Hinton indicated, we are recommending a prison term of 8 months. When we were here back on December 1st and we wanted to proceed to sentencing, one of the reasons that we wanted to do that, and I know the court's concern now, is that if there's a prison term imposed, that he won't go there for, it may not go there right away or may not go there because there's not as much time left. I think that's what Mr. Hinton and I contemplated when we made that recommendation on the first.
So I'm supposed to sentence someone without knowing anything about him, anything about the crime?
No.
I mean, it's a responsibility I have, and that's what you were asking me to do. And I wasn't going to do that without knowing anything about the offense, anything about the defendant. So you're sort of shifting the blame to me that now there's not enough time to do the joint recommendation because I said I wanted to get information about the defendant so I can make an educated decision before I make a decision that affects someone's life.
That's not my intent, Your Honor. What I'm saying is that Mr. Hinton and I contemplated the time that he would be spending in at that point in time.
We should have contemplated then giving the court enough time to review a case instead of just blindly going along with what you guys think is right.
Understood, Your Honor. In this particular case, there is economic harm. Obviously, there's restitution in the amount, and it's been requested of the $12,000. The reason that we did not recommend community control is because he did have an additional charge, and he's awaiting extradition then to Missouri as a result of that. He had to be extradited here, so we contemplated that and not recommending community control. We felt that the minimum would not have been appropriate, and so that's why we recommended the 8 months in prison. So I would ask that the joint recommendation be adopted with the credit for time along with the restitution order.
Thank you. Court reviewed a pre-sentence report and investigation, considered the facts and circumstances of the offenses involved, the nature of the offenses involved. I received a victim impact statement from the victim in this case. I've read and considered that, which I didn't have at the time of, I don't believe I had that at the time of sentencing. Plea. I didn't. So I've got a victim impact statement now, and I've read and considered that. Consider what's been said here in court by the defendant, his lawyer, the prosecutor, the joint recommendation presented. All this is considered in light of the purposes and principles of felony sentencing set forth in 292911. So the factors in 2912. Factors indicating the conduct is more or less serious. The court notes that the victim suffered serious psychological harm as well as economic harm as a result of the defendant's conduct. The relationship with the victim facilitated the offense, and the sheer amount of damage caused by the defendant is way greater than what we normally see in a vandalism charge. $90,000 in damage, which at the plea I was represented with $60,000. But it looks like it's $90,000. And that's something I wasn't aware of until I did a PSR. Nothing indicates it's less serious. As for recidivism factors, the court notes that there is a history of criminal convictions, albeit not a significant history, but the defendant had a prior case in front of this court back, 2007, I think it was. Had a weapons charge back in 2014, which was reduced to a misdemeanor. And then this charge, he does have a pending case in Missouri, which he will be extradited to once this is concluded. I don't believe there's genuine remorse. I mean, today he stood up here and said stuff, but when he had a chance with the PSR, all he did was he acknowledged committing the physical act, but he basically said everything he destroyed was his own, which he didn't think there'd be anything wrong with that. Well, first of all, that's not true. I mean, you damage the structure of the house. There's holes in the walls. Along with a lot of other damage. He's sorry he's in the position he's in now. So factors indicating recidivism is less likely. Court notes that the defendant led, despite the 2 convictions, he's led a law-abiding life. For a decent amount of time, it was 10 years between the misdemeanor charge and this, and it was what? 16 years or so between the felony charge and this. Court finds in this case that prison is consistent with the purposes and principles of sentencing. Defendant's not amenable to an available community control sanction with pending charges in another state, which will cause him not to be here. Again, the sheer amount of damage caused to this house, $90,000, and when you read all the actual damage that he did to the different property and items in the house. One of the worst vandalisms I've had. I don't believe the joint recommendation reflects a proper penalty. Therefore, it's a sentence of this court. Now, the sentence I'm going to impose is not what I believe should be done either, but I'll give some credence to the fact that there was a negotiation here and a plea. But it's a sentence of this court that on count 1, defendant serve a term of 90 days. On count 2, vandalism charge, you serve a term in prison of 10 months. On count 3, you serve 180 days. All 3 counts are concurrent with each other for 224 days of credit. Again, the sentence in the vandalism would be much higher if it wasn't for the fact that your lawyer negotiated this deal with the state and worked this out. You need to advise you upon your release. You could be placed on post-release control for 2 years. If you are on post-release control and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 5 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay all costs, and restitution to the victim in the amount of $12,000 is being ordered. Ms. Linden, is there anything else for the record?
No, Your Honor, thank you.
Mr. Hinton?
Nothing further, Your Honor.
Okie dokie, friends. It's the Courtroom Files Live, episode 202 today, the last of the year. Good to have you all with me today. Let's go. Yeah, let's go back up to Michigan. We'll see what's going on with Corey Wiggins.
On every prior matter.
Okay. All right, if we can just want to file a corrected appearance, I'd appreciate that. So we are set for a probation violation hearing on both of these files. However, I have received an amended violation bench warrant. So we are going to arraign on that amended one. The prior violation was, thank you, that the defendant had violated probation by testing positive for methamphetamine on December 22nd. Today's amended bench warrant request has that same violation, but also that the defendant is in violation of probation by failing to test on December 27th, thereby resulting in a missed test. Mr. Pruitt, again, you do have the right to be represented by an attorney in this hearing. You also, if you are found guilty of the violations, you could be sentenced to what you could have been sentenced to under the original convictions. In 25373, SM is up to 93 days, and in 252722, up to 1 year. Do you understand that? Mr. Hartel, the court will enter a not guilty plea to the amended violations today. Now, I know we are here for a contested hearing, but Mr. Hartel, were you aware of the amended warrant coming through?
Not before coming in this morning. I was given one by the probation department while I was here. I do believe my client and I have had ample opportunity for court wanting to do a single hearing today, though. Thank you.
Okay. You think you're prepared for both?
I do believe so, yes.
Any objection to that, Ms. Lawrence?
No.
And so are we then having the hearing? We're not, it's not a plea.
We would ask for a hearing. Yes.
All right. All right. Then we will go ahead and do the hearing. Ms. Lawrence?
We'll call Melissa Goodman.
Solemnly swear or affirm the testimony you give in this matter will be the truth, whole truth, and nothing but the truth?
Yes.
You may have a seat. And whenever you're ready.
Can you please state your name for the record?
Melissa Bismarck.
And what is your occupation?
I'm the 84th District Court Probation Officer for Wexford and South County.
And are you supervising a man by the name of Daryl Pruitt?
Yes.
Do you recognize him in the courtroom today?
Yes, he's sitting with his attorney at the defense table.
And what's something he's wearing?
Blue checkered flannel and a black sweatshirt.
Your Honor, may the record reflect the witness has identified the defendant.
Mr. Hartel?
No objection, Your Honor.
It shall so reflect.
What are some of the terms of Mr. Pruitt's probation?
Mr. Pruitt is supposed to be testing randomly for drugs and alcohol and counseling. He was released from treatment and enrolled back in the random testing, and that was on 12/17. His first test after being released from treatment was on 12/22, and he was positive for meth.
Okay. And so part of that random testing is that he not consume illegal controlled substances, correct?
Correct.
Okay. Was that test in person on the 22nd?
Yes. Okay.
And that was showing positive for methamphetamine?
Yes.
You said, what date was he released from inpatient treatment?
That was on 12/17/2025.
And then was he lodged for that violation on the 22nd?
He was, yes.
Okay. And then do you know when he was released?
He was arraigned on the 23rd of December and given a PR bond, so he would have been released that day.
Okay. And then was he supposed to come in for a random test on December 27th?
He was.
Okay, and what happened on that date?
That would have been on a weekend, so he appeared to test with community corrections because they're open from 6:30 to 8 on weekends. Travis, who would have administered the test, gave him multiple attempts, and he was there from 7:20 a.m. until 9 a.m. So he stayed an hour after they were supposed to be closed to try to get a sample from Mr. Pruitt, and he was unsuccessful.
Okay, so he never gave a sample for that test?
No.
I don't believe I have any other questions at this time.
Thank you. Mr. Hartel?
Yes. Thank you, Your Honor. Ma'am, for the 22nd, when he tested positive, were you the one doing the test that day, or was that somebody else?
That was Taylor Brecka. I was not in that day.
Do your notes reflect, or do you otherwise know if my client said anything to explain why there might be a positive or a false positive?
I have a note that she wrote in the file that he tested positive, states he went to a friend's house, may have touched meth, and that he took a single hit of a cigarette that was lit.
Did you follow up with him on that by chance?
I have not.
When it comes to the 27th for not being able to submit to the test, I'm assuming we're talking about a urine test?
Correct.
Does your office also offer mouth swabs, anything like that?
Our office does, but again, he was testing with community corrections because it was on a weekend.
Oh, and your office isn't available on the weekends?
No.
Okay. Do you know if community corrections, if you know, do they offer the mouth swabs?
If I ask for one, like for a female especially, I might ask for a mouth swab because there's a male tester there. But since they're both males, I do not ask for a.
You have to make the request in advance.
Correct.
Okay. I believe you've answered my questions.
Ms. Lawrence, any redirect?
Just a couple. How long did you say that community corrections gave him to provide a urine sample?
He was there from 7:20 a.m. to 9 a.m.
And you said sometimes you offer the oral swab to females if there's a male tester there. Is that your decision whether you want to offer that or not?
Yes, we make the decision based on a number of things regarding male or female. If we believe that maybe they've been using a clean out kit or other reasons like that, we would ask for an oral test.
I have nothing further.
Thank you. Any recross, Mr. Hartel?
No, thank you.
May this witness be excused?
Yes.
You may step down. Any additional proofs, Ms. Lawrence?
No, Your Honor.
Mr. Hartel?
My client would wish to testify on his own behalf, Your Honor.
All right, Mr. Pruitt, if you'd come up here, please. You solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may have a seat. And whenever you're ready, Mr. Hartel.
Thank you, Your Honor. Sir, on the 22nd, what happened that day that you believe might have led to you testing positive?
I gave a guy a ride to his friend's house, and I didn't know that he was even like that because I known him for some time. And I asked him for a cigarette when I was sleeping. That's what was going on. I might be around that kind of thing. And I asked him for a cigarette. He gave me a cigarette. I walked outside and I lit my cigarette, and I could taste something funny in it. And I immediately threw it down, and I knew what it was because I had consumed it before. So it was not intentional that I did that. It's not something I was looking for, something that I wanted it to do. just in that cigarette. And that's what caused me to test positive the next day.
And did you communicate that information to somebody at that testing location?
I did.
Okay, was that pretty similar to what we just heard testified to a minute ago?
Yes.
Okay. What happened on the 27th?
I got up in the morning. I just woke up, I don't know, probably around 6:30-ish, something like that. And I didn't even know what time it was. I just went to the bathroom and I seen the time it was. It was 6:30 when I seen the time, and I called the number, random numbers I called. And I had to go test, so I came to community corrections and I didn't have to urinate. And I tried to drink a lot of water and do that, and I still couldn't. Probably because I just used the bathroom, before I came. I didn't know what time it was in the morning. And I asked the gentleman if I could do a mouth swab, and he says, they don't do that. And I says, well, can you please call Melissa Bismack and ask her? He did not. And I was willing to do a mouth swab that morning because I do my violation. Because I'm clean and I have been clean, staying clean.
All right, and you mostly answered these already, but I want to be very direct and very on point with it. Since completion of treatment, have you consumed any illegal substances intentional?
No, sir.
And did you have every intent to provide a sample on the 27th if you couldn't physically been able to?
Yes, I did. I had every intent to do so.
All right. There might be some additional questions, but thank you for your time.
Thank you.
Thank you. Ms. Lawrence?
You said you've known this friend for quite some time. How long would you say you've known this friend?
About a year and a half.
Okay. Is this a close friend?
I would say I would consider him a close friend.
But you had no idea that he was a methamphetamine user?
No, I did not. I've never known him to do such things.
You are aware that part of your probation is not to consume controlled substances, correct?
Yes.
And you are aware that when you're called in to test, you are expected to test? But did you test on that day, on the 27th?
I couldn't, I did not, because I didn't have to use the bathroom.
And although you're claiming you did not intentionally consume methamphetamine, is it true that you tested positive for methamphetamine on the 22nd?
Unintentionally. She said that I tested positive for it. That's the only reason from that cigarette that's the only reason. Because I did not intend or have any intentions of doing anything illegal at all.
Mr. Hertel, any redirect? I'm sorry, redirect?
No, thank you.
Mr. Pruitt, I have a couple of questions. You said that you had drank a lot of water. How much water did you drink?
I drank about a bottle and a half, 2 bottles. I'm assuming because of the water fountain.
So you were drinking out of the water fountain?
Yeah, and I used the little tiny cups that they have.
Okay. Like the Dixie cup size?
Yes.
Okay. And then how many attempts were there to use or to provide a test?
I only tried once for him. I have to go and ask if I could wait a little while. He said yes.
And when after arriving was it that you attempted that first test?
It was about 20 minutes.
Okay. I'm sorry, 20 minutes to half an hour, is that what you said? And what time did you check your numbers?
About 6:30-ish.
What attempts did you try to, did you make any attempts to consume water before coming in to test?
On my way. Water bottle that I had.
How much is not a lot?
It was probably a quarter bottle of water.
Like a normal size
Yeah,
bottle?
12 ounce.
And how long of a trip did you have to community corrections?
It was about 40 minutes.
Okay. Ms. Lawrence, does that raise any additional questions?
No, Your Honor.
Mr. Hartel?
Just a few, and I'll try not to be too embarrassing about it, but I think I kind of have to. You mentioned that you urinated at some point in that morning, correct? About what time was that?
It was before 6:30, before I called. What time it was in the morning.
When you did urinate in part, was it because you had to go pretty bad first thing in the morning?
It woke me up.
Fair enough. Different people's bladders are different, especially as people get older, especially with men, things like that. How long does it normally take you, once you start consuming the amount of fluid you were mentioning, before you normally have to urinate?
It's usually a few hours. I don't use the bathroom a whole lot. I don't really drink a lot of water. I drink more pop and things like that.
The type of jobs you've done, maybe you have to be able to hold your fluid so your brain works the same way?
Yeah.
All right.
I work in a lot of factories, so we couldn't always use the bathroom.
And although this may or may not be something that comes up at the court's discretion, if the court did order you to test right now, do you have every reason to believe you would be clean?
Absolutely.
All right, well, that may or may not be something the court asks of you. It is one of your bond conditions with your PR bond and being on probation. There may or may not be more questions. Thank you.
Thank you. Ms. Lawrence, does that raise any questions? Mr. Hartel, may this witness be excused?
Yes, Your Honor.
Mr. Pruitt, you may. No, it has come through the form of a question. Any additional proofs? Well, actually, Mr. Hartel, I'll let you talk with your client to see if you want him to testify about something else.
I appreciate that, Your Honor. There is one other question. I don't know if the court wants me to take the stand again or if it's okay where he is.
But where he's at.
All right. Sir, I believe I may have heard your agent say that the 22nd was the first time that you tested since coming back from treatment. Were there any prior tests prior to that?
Yes, the 18th, the day after I got out of rehab.
What happened during that test?
I was negative.
All right. I thought it was the only other test before the 22nd?
Yes.
All right. That was the only additional question. Thank you, Your Honor.
Ms. Lawrence, does that raise any questions?
No,
All right. Any rebuttal witnesses, Ms. Lawrence? Or I'm sorry, Mr. Hartel, did you have any additional proof?
Oh, no further proofs. Thank you.
Any rebuttal?
No, Your Honor.
All right, argument then?
Thank you, Your Honor. While I understand Mr. Pruitt is claiming he did not intentionally consume methamphetamine, I'm going to be frank, I find that extremely hard to believe. Whether it was in his intention or not, he is taking a random laced cigarette from a very good friend that he is unaware is a methamphetamine user. I think is pretty hard to believe. Given that, whether he intentionally did it or not, he did consume methamphetamine and he admitted to that. He admitted that he tested positive on the 22nd, and he also admitted that he essentially refused to test on the 27th. I understand it takes some people longer than others to pee, but that is his responsibility in the morning to check his testing number and to come in and to test when told to do so. I'm drinking that much water. I mean, Ms. Bismack stated he was here for 2.5 hours. If he checked his number at 6:30, he knew he had the test. Ms. Bismack said he was here from 7:20 till 9 a.m. From 6:30 to 9 o'clock, that's essentially 2.5 hours of him drinking a ton of water, as he says, and still not being able to test. That is on the responsibility of Mr. Pruitt to know when to test and to be able to test when told to do so. So I would ask the court to find Mr. Pruitt guilty of both probation violations. Thank you.
Okay. Mr. Hartel?
Yes, Your Honor. I'd ask the court not to find my client guilty of these two counts, as he did testify to, and as the other witness testified to was mentioned to her department at least. My client has been firm on the fact there was no intentional consumption. He's been consistent with his communications to people in the probation department here on the record under oath. I take him for his word on that. I also asked the court to factor in that he did testify that he did attempt to provide a sample. As has been noted, everyone's bladder is a little bit different. He did testify that he had attempted to request a mouth swab. I don't think somebody who believed they were going to come up positive for drugs would do that. We realize the departments have their policies for the reasons they have their policies. I respect that, but I do believe he did not intentionally avoid testing. He was physically present. Most people, I don't want to oversimplify it, but he did show up and ask the court to factor that in at a minimum. There was testimony that he did consume fluids. I asked the court to take that under weight as well, I'll phrase it that way. I do believe that the fact that he said that he was willing to test today, even in my mind at least, goes to the mentality that he knows he would be clean. Why would somebody who knows they're going to be clean fail to provide a sample? It just doesn't make any sense to me. Any further allocution I'll reserve for if there's a finding, but again, I'd ask for the court not to find him guilty of either of these counts. Thank you.
Thank you. In rebuttal, Ms. Lawrence?
Yes, Your Honor. I think the fact that he showed up to test on the 27th does not automatically mean he was clean. This happens all the time, and not saying Mr. Pruitt's case is just like every other case, but people raise their hand and offer to test for us all the time, promise they're going to test clean, and then when the court actually orders them to test, they don't. This is not the first time this has happened. While I understand he was here and trying to test, in his opinion, he did not test. So we'll never know if on the 27th he would have tested clean or not, because he did not provide a sample when he was supposed to.
Thank you. Based on the testimony presented today, I do find that the defendant is in violation of his probation by testing positive for methamphetamine on the 22nd of this month. I also find that he's in violation for failing to test on the 27th. While he may have presented himself for testing, the fact remains that he did not test, and probationers do not get to choose the form of the test that is presented to them. In this case, it was a urine test. Community Corrections was with the defendant for 2.5 hours during that period of time. And actually before that, because he drank about a quarter bottle during his 40-minute trip to town. So that would have been roughly 2.25 bottles in his estimate that he drank of water, and during that period of time could not provide a urine sample. It doesn't take a whole lot of urine to give a urine test. So while he may have presented himself, he did not test. In regards to the positive test for methamphetamine, he may not have knowingly ingested it, but the fact is that he did ingest it, and a heightened sense of security needs to be there when one is on probation. So I do find the defendant in violation of his probation. By my count, this would be 3 technicals with the prior. Is that correct, Ms. Bismack?
Yes, Your Honor.
All right. Has everybody received the recommendation in this case?
As we are.
Is there any corrections to it by either party?
No, Your
No, Your Honor.
All right. Allocution, Mr. Hartel?
Yes, Your Honor. When it comes to actual sentencing, I do realize the court has a bit of discretion here. I'd ask the court to factor in that even though there's been a finding of consumption, as the court did note, there was testimony that it wasn't intentional. There was testimony of my client at least attempting to provide some type of sample as far as testing. We realize those don't reach the thresholds that the court requires. We realize that's why there's been a finding, but we still ask the court to factor that into reasonableness for any potential punishment. He is again willing to test right now to prove he's clean right now, if that mattered at the court. He's been trying to do everything right. He's been trying to respark good relationships with some family, weed out some friends that he realizes he should have weeded out before. This really scared him straight a bit, realizing, hey, he was being near somebody who may or may not have some issues, even if it's somebody he didn't necessarily think was that big of an issue. He wants to be as safe as possible. Only people who are 100% on the straight and narrow. He's also been applying to a variety of jobs, I believe Gill Staffing and a few other places, Sarah Lee, maybe if I recall correctly. I do believe he has a statement he'd like to say in a moment as well. But again, he's highly motivated to test today to prove to the court he's clean if given that opportunity, if the court believes it has any weight whatsoever. Thank you.
Thank you. Ms. Lawrence?
Thank you, Your Honor. I would ask the court to follow the probation recommendation. Speaking with Ms. Bismack, Mr. Pruitt did inpatient treatment, and although he did that successfully, inpatient treatment is, as hard as it gets. And the fact that he is still testing positive after completing inpatient is extremely concerning to the people. So I would ask for the 15 days jail. Thank you.
Thank you. Mr. Pruitt, you do have the right to address the court prior to sentencing. Is there anything you'd like me to know?
Yes, sir. I did not knowingly or intentionally consume anything illegal. And I have been trying to find a job in Sarah Lee, and I do plan on moving away from people, places, and things. I'm just got to get a job in order to do that. I better myself. And I do take my sobriety very serious. As far as rehab, I did 37 days and take it very serious and helped me a great deal. I'm understanding a lot of different things, a lot of reactions, a lot of stuff. People learn a lot. And it really helped me quite a bit. And I appreciate that opportunity to grow from things I've done wrong. I did test the day after I got out of rehab too. I was 18 and I was negative. And the 22nd, I did not knowingly consume or be around me. That's like that at all. I have any intentions whatsoever, or even anything whatsoever to do anything, anywhere again in my life. And that's just the way that it is for me. I can't speak for myself. I do not want that kind of life anymore. I am not going to have that kind of life anymore. And I'm trying to better myself as a human being in this system. That's them are my intention to do, and that's what I am going to do.
You said you're trying to get into Sarah Lee?
Yes, sir.
How long has that been going on that you're trying to get in there?
I put in an application while I was in rehab. So it's been about 2.5 weeks.
Have you heard from them at all?
I called them. I haven't heard from them. They said they were kind of hiring freeze till the first of the year. So that's where I'm at with them. I also put in applications at Gill Staffing and Warden Staffing. I'm willing to take any job I have at any point. It doesn't matter to me what job it is, as long as I have a job.
How are you supporting yourself now?
Right now, I'm staying with my daughter, my youngest daughter. She's 25. She lives in Everett. That's where I'm staying at right now. So I'm away from people, things like that. I've cut a lot of people out of my life. And that's better for me. Helps my situation. That's what I'm trying to do. And not knowing consume anything or intently at all. And I was very upset when I realized what was happening. That's why it caused me to test positive. And I was very upset about that.
Did you say anything to the probation officer before you tested about you knew you were going to test positive?
I did not. I didn't know that I was going to. I think that's positive for that.
But out of precaution, you didn't say, hey, yesterday I accidentally smoked this meth-laced cigarette?
No, it was on Sunday.
Okay.
So, and I had to come and test it on Monday. And that's how
Yeah, so it was Mondays when you smoked it.
No, Sunday.
I'm sorry, Sundays when you smoked it, Mondays when you tested.
Yes, and it was only one, I just lit it, and I realized what was in it, and I threw it down immediately. And I was verbally upset, I was yelling at him, you know, and I just left, and I didn't know what to do.
Why didn't you say anything to the probation officer? That, hey, there's this chance that I might test positive and this is why.
Mr. Smith wasn't there, and Taylor, I explained to her what had happened.
Before or after you tested?
It was during the test.
Okay.
So I had no intention of, or knowing try to do anything. I'm being punished for it. Like I said, I didn't know him to be that way. And it's been, I guess, a few months since I actually seen him. A lot of things can change in that time. So where I'm at with that. I apologize for it. And it's not something I'm going to continue to do or even want to do. It's not even a thought in my head.
All right, anything else? Well, Mr. Pruitt, from where I sit, your version of events, while I can maybe see them and understand how things happen, it's hard for me to wrap my head around it. It's hard for me to believe that right after rehab that you're ingesting some sort of meth without knowing what it was. And it's also hard for me to believe that in a 2.5 hour time period, you could not produce enough urine to provide a sample. When allegedly just a few days before you had used methamphetamine. However, with that said, you are now in a position where you need to sink or swim on your own. You know, I could put you in jail for up to 15 days because this is your 3rd violation. And by all intent and purposes, I should do that. However, if it is as you say it is, that it was not intentional and you couldn't provide urine because you had used the bathroom 3 hours before, then I'm not sure there's anything I can do to help you with that. It's all on you. You're the one who knows your bladder. You're the one who knows what you have to do. You're the one who knows that you're not supposed to consume meth, and you don't have a problem with that the way it sounds. So, as I said, this is all going to ride on you. There's going to be 1 day jail, 1 day credit on the violation. Like I said, you should be getting 15 days, but there's nothing we're going to get out of that the way it sounds. I'm going to continue probation. I am going to order increased testing at the discretion of Ms. Bismack. And hopefully we won't see you in here again. But if we do, we know whose fault that is, right? And you also know that you're out of excuses. You now know that shouldn't be bumming cigarettes off people, and you know now that you have to test when you have to test, and that you don't get to choose the method of testing. So just keep that in mind. You can go up to the front window where you checked in, get a copy of the order. And Ms. Bismack, does he need to report today?
Yes, sir.
And then make sure you report downstairs. All right?
Thank you.
Okie dokie, friends. Let's head back to Ohio. Judge Collada has a new contestant, and based on where the clock's at, this will probably be our last hearing of the year. Let's give it a look.
Your Honor, we're hearing case caption State of Ohio versus Leland Atwater, case number 25 CR 001313. We were last here on December 16th, at which time the defendant entered a written and oral plea of guilty to 2 counts of failure to appear, felonies of the 4th degree in violation of 2937.99. The case was set for sentencing today, and defendant is present with his counsel, Ms. Rachel Smith.
Thank you. Ms. Smith, any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. We are asking the court to impose a minimum prison sentence on this matter and to impose the sentences on counts 1 and 2 concurrent with each other, with the understanding that they must be imposed consecutive to the sentence that Mr. Atwater is already serving and that has been imposed by this court. Your Honor, this court is not unfamiliar with Mr. Atwater, and it's rather heartbreaking to have to stand next to him at sentencing, knowing that he will be sentenced.
You don't have to stay at this point.
To
No
prison.
disrespect. Just let her, and then you can speak after that.
Mr. Atwater is a veteran. He was honorably discharged, and it appears that he served his country well. And as part of that service, he sustained a traumatic brain injury and suffers from the effects of post-traumatic stress disorder to this day. Your Honor, I genuinely believe that it's that PTSD that, while it doesn't excuse his conduct on either the original case that brought us here or on the failure to appear, it does offer help us understand it. How someone like Mr. Atwater, who's respectful, does not have a criminal history, it could end up in this position before the courts. And I think that through this case, these 2 cases, Mr. Atwater has learned that he does need to address his PTSD. When his fight or flight kicks in, he flees. And as evidenced by the failure to comply cases and his fleeing the courthouse on the date of his sentencing originally, I think that Mr. Atwater has genuine remorse for his conduct and the disrespect that he showed this court. As I indicated at the beginning, it's heartbreaking to see Mr. Atwater go to prison because he's not somebody that belongs in prison, but he understands that this court has no choice but to impose prison. And we would ask that the court, considering the foregoing information, would impose a minimum prison term on each count concurrent with one another and consecutive to the sentence which she's serving.
Thank you. Mr. Atwater, you do have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time? And you can stand, sit, whatever you feel comfortable.
I just want to apologize to the court, to my family for putting y'all in this position. And I was not trying to, I did not premeditate the situation when it happened. The news just kind of caught me off guard, and I guess I panicked and I did the wrong thing, Your Honor. Sorry.
Thank you. Smith, anything else?
No, Your Honor, but Mr. Atwater's mother is present in the courtroom and I believe would like to address the court.
Sure. Ma'am, you can stand right there, state your full name so we know who's speaking, and then say whatever it is you'd like me to know. Make sure you keep your voice up loud enough so we get it recorded.
My name is Monica Atwater. I'm Lily's mom. And my mom passed away a few years ago. And I have an autistic brother. He was diagnosed with autism from birth. So my mom, she had to care for him because he needed 24-hour care. So when she left here, I had to take him with me. So I had to retire early. So Leland was there to help with all of the needs because I have family members, but like they were okay in the beginning, but after a while, there was nobody there to help me. So by him needing 24-hour care, my son was there to help. He needed bathing. You have to feed him, you have to bathe him. I mean, that's a lot for me. And I was doing that on my own. So he's gone now. I don't have anybody to help me with that. But I'm just saying his caring and loving of my uncle, my brother, his uncle, my brother loves him because he's aware of what's going on, but he just can't take care of himself. So, he misses Leland tremendously. And it is true about the post-traumatic stress. Before he went to the military, he was a good person. He still is a good person. But he saw a lot of death, and it's things that he wanted to talk to me about, that he came back with. He went a non-smoker and a non-drinker. He came back, he was a chronic smoker. He drinks because of trying to, the things that he saw and that he dealt with, it was hard for him. So, I'm there for him, and he doesn't mean to be the person that he is, but he still feels those things. He can't get rid of that. And I'm not saying that what he did is excusable, but I know that he needs help. I do. So I'm hoping that the court takes that in consideration as well. And then I also heard that it was something about him trying to flee to Canada. I'm the one going to Canada. I date a man in Canada. So I go back and forth to Canada like 2 or 3 times a month to visit the guy. So, and he lives in Windsor on Patrice Drive in Canada. And he's the ex-deputy chief of police for Windsor. So if I need to, he can validate that. I forgot to get a letter from him, so he can validate that. But our phones are on we share phones. My daughter and my son, they're on my account. So I'm the one that's going back and forth to Canada. If that was a problem, because I wanted to write that in the letter too, but I forgot to put that in.
All right, thank you, ma'am.
Thank you.
I'm good. Ms. Smith, anything else?
That's time.
Ms. Linden for the state of Ohio.
Thank you, Your Honor. Your Honor, as I indicated in chambers, the state would leave any sentence to the court's discretion. I would say that based on what the defendant's mother has said, that certainly explains why the phones, according to the Sheriff's Department and through the U.S. Marshals, were pinging in the Canadian area. So certainly I understand that, but we would leave.
I don't know about that. I'm not saying it does, doesn't it? Daughter was in Europe all last semester. I was never in Europe. The same family plan.
So, Your Honor, we would just leave that to the court's discretion. He would not have credit for any time served, and I understand that it needs to be consecutive to the sentence that's imposed in 127.
Well, the court has considered the particular facts and circumstances of this offense and the nature of this offense. Considered, it's been said here in court by Ms. Smith, the defendant himself, his mother, the prosecutor. I received a letter from the defendant this morning. I read that prior to coming out and considered what that's had to say, or what he had to say in the letter, I should say. All this is considered like the purposes and principles of felony sentencing set forth in 29-29-11, for the factors in 29-29-12. Nothing's present making it. I will say, actually, the defendant initially showed up, which is normally don't have that. Then he left before we can do the hearing, but I guess that's a little less serious than normal. Recidivism factors incorporate the findings I made at the last hearing. Court notes the defendant is currently serving a prison sentence in another case. The prison is consistent with the purposes and principles of sentencing. Defendant is not amenable to community control sanctions. Will therefore sentence the defendant on counts 1 and 2 to a term in prison of 6 months. run those terms concurrent with each other, but by statute 29-21-331, they must be served consecutive to any prison sentence. That'll be consecutive to the term he's serving in 25 CR 127. Since it's consecutive and all the time overlaps, there's no credit on the new case. On the fleeing and eluding, not the fleeing and eluding, and the failure to appear cases, 13. I need to advise you upon your release from prison. In this case, you could be placed on post-release control for the 2 years. If you are and you violate any of those conditions, the parole authority can send you back to prison as punishment for violating the rules for another 9, in this case 3 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time, and defendants order to pay all costs in this case. Is there anything else for the record in this case, Ms. Linden?
No, Your Honor, thank you.
Ms. Smith?
Not on behalf of Mr. Atwater.
Okie dokie, friends. That brings a conclusion to our live content here on TCF for this year. Now, we will have best of shows in this time slot for the rest of the week, so we will have stuff for you. Please do tune in, hit the like button when you hear stuff like that. And we'll be back live Monday. Now, next week, we'll keep our current schedule, so 10 a.m. Eastern, 7 a.m. Pacific. But starting on January 12th, we're going to move to 9 a.m. Eastern, 6 a.m. Pacific, and we will be adding a 4th hour to the show. So be sure to check us out for that. I want to wish everybody a happy new year. I hope you all enjoy the next couple of days. Please stay safe, because sometimes we don't stay safe on New Year's. And I want you all back here with me on Monday, because it's been an honor to spend this last year with all of you. It's been one of the best years of my life from that standpoint. Just the new friends that we've made and the fun that we've had here. It's been great. So thank you all so much. Anyways, enough of that. Go have yourselves a great day, a great New Year's Eve and New Year's Day, and we'll see you all live on Monday, and perhaps I'll pop in on the best of and say hi to all of you when those are running. But take care. God bless.